starting at 6:30, the firm of Dutch Williams, Brooks, Durensis, and Holland. At 7, Kopelman and Page, PC. At 7:30, Myris and Harrington, LLP. At 8 o'clock, Murphy, Hesse, Tomey, and Lehane. At 8:30, Blattman, Brabowski, and Mead, LLC. And at 9 o'clock, Gellerman and Cabral, LLC. I apologize for mispronouncing many of them. And then following the interviews, we'll convene, and we have standard questions, which I'll explain, and then the rating system. So hopefully at the end of this meeting, we can put our minds together and get some directions for the following meeting. So, Linda, you want to lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so just some of the logistics. We had asked Chris to make sure, even though it's a public meeting, that the other candidates aren't sitting in the room as a courtesy, professional courtesy. What we handed out are the questions with some room for notes. Following that is a rating sheet for the 6 firms, and then the last page is a Excel spreadsheet matrix that Lorraine had put together that kind of summarizes the bits and pieces from all 6 of the packages that we got. So before, I guess, the first firm comes up, does anyone have any questions or suggestions on how the meeting goes? Go with.
I think it's important, though, that we try to stay to the half hour for each. Just try to stay on.
Absolutely, because the 6 firms, and even if it's a half hour, that's 3 hours.
Yeah.
I do have a prepared statement that I wanted to read to each of the firms, just to kind of give the guidelines so they'll at least know what's expected. Okay. So being a little after 7:30, if
6:30.
6:30.
Yep.
Do you want to come up to the table? Right.
Yep.
Excuse me.
Let me get your chair.
Oh, come on.
So first.
Thank you. And before you introduce yourselves, I'm just going to read a prepared statement that I'm going to read to every firm that comes in. It's a minute long. On behalf of Foxborough Board of Selectmen, I want to say thank you for your interest and effort in providing a proposal to offer town council services to our town of Foxborough. We have received your application packets and have had time to review it prior to this meeting. Tonight, we are interviewing 6 firms, and we have allocated 1/2 hour to each firm. Time will be structured so we can allow ample time for your firm as well as the other candidates that come in this evening. Our standard format will be as follows. You will be given 10 minutes for an opening introduction to describe your firm's qualifications and perhaps the reason that your firm is best suited for Foxborough's needs as our town council. Following your 10-minute introduction, there will be 15 minutes of Q&A. Each of our 5 members will ask you one question, and we will not ask you a follow-up question. And we will use that time to listen. Following the 15 minutes of Q&A, you'll be given 5 minutes at the end to offer a closing statement. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for a second follow-up interview where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed. Should the public have comments from this interview process, time will be provided at our next meeting during citizens' input. Foxborough Cable Access TV is broadcasting this interview live for our residents at home, so if you could use the microphone and speak up, that would be appreciated. So again, thank you for the time, and with this introduction, please proceed.
Thanks. I'm Paul Durensis from Deutsch Williams. With me is Kim Salant, who is one of our trial lawyers, and Rod Hoffman, who's a contract, procurement, and economic development attorney. I think we're a known quantity for Foxborough, but if I had to summarize what we stand for, I would use 4 words: independence, continuity, stability, and accomplishments. And let me say something about each of those words that we use to describe us. We're independent in that we feel quite free to say no when no needs to be said. As outside counsel, we see our job not just going along, but when something is wrong or something is illegal, to stand up and say, you can't do that. We have tried to do that in the past without being disagreeable. We see sometimes when we're dealing with some of the players here in Foxborough that they are looking for the best deal that they can get. And our job is to get the best deal that we can get for the town and for its taxpayers. So there will be disagreements, there will be areas where there are competing goals, with each side trying to accomplish the best for, in one case, for the private interests, and the other for the public. But we can do so without being disagreeable, and we can do so in a way that keeps the dialogue going. We're independent in the sense that our work is our own, not something pushed upon us, not something that we're lobbied for. We understand we report only to the Board of Selectmen and to the people of the town. I use the word continuity to describe us. Continuity because we are, to use a football analogy, we're in the middle of a drive down the field. We're heading for the end zone on a couple of big issues. We're getting first downs. We're making progress. We represent the continuity of those goals by the town and a real opportunity to score on those goals. As part of continuity, we see ourselves as part of a team, and our method of operation is to be part of a team and to put teamwork as an important characteristic. For example, in recent negotiations, we have a team that has the DPW superintendent, we have the finance director, we have the town manager, we have a representative of the Water and Sewer Commission, an excellent team, but we're part of that team, and we see our role as being part of that team. A third word that I've used to describe us is stability. A lot has happened in the last year. If we look back a year ago, last June, who could have foresaw everything that would have happened to this community in that year? We see that this is a time that the community needs stability, needs healing, needs continuity, and we represent that. And the fourth word that I used to describe us was accomplishments. We have done a lot for Foxborough. We're proud of what we've done for Foxborough, and we're proud of Foxborough for being part of all of these things that got done. I should say that Foxborough is not any longer the small little town that it once was. Back in 2007, this community embarked on Patriot Place, and back in 2000 or 1999, they embarked on having the only NFL franchise in New England. So in essence, we see two Foxboroughs together. We see a small town, and very much of the small town, a small town that should be preserved. On the other hand, we see a world-class municipality that has the same problems and the same issues that the city of Boston has. And it is in that context where we have to both be counsel for a small town and yet have the resources to deal with unexpected challenges. Last year, as I say, we didn't foresee what was going to happen this year. And because a lot happened, the town, as a town, and we as your lawyers, ultimately were prepared to handle those challenges. And the community did handle those challenges and did come through it. And we think we helped. That was through hard work, preparation, teamwork, education, and expertise. Here are some specific things just to remind you of the role that we played.
Okay, just to keep you on track, you get about a minute left for the opening.
Well, then rather than go through that, let me ask him to say a few words, if I could.
I'll be quick. Let me draw your attention to page 3. I'm a litigator. That's the way we talk. On my 26th year as a litigator, I started out in private practice. Page 3 of the proposal will have a detailed list. Thank you. I'm used to standing up and walking around. Detailed list of the accomplishments that we have done with the town of Foxborough in greater detail than Mr. Durensis could tell you in 10 minutes. I won my first suit before I graduated from law school, and that was over 26 years ago. And I have successfully maintained that record. I represented boards of appeals, planning boards, conservation commissions, boards of selectmen, town managers, town administrators, planning boards, building inspectors, zoning enforcement officers. I was instrumental in the litigation involving Weston and Sampson, which you all know was a 30B litigation, which actually, when you crunch the numbers, we all know what the original estimate for that project was. We all know what the bids came in. Had Weston and Sampson been successful in their preliminary injunction, and they were not, we would have gotten bids substantially higher than initially we had received in the first round. I applaud DPW director for making that decision. It was a tough row to hoe, and he stood his guns, and you know what? He was right, and it saved this town a lot of money. And Deutsch Williams was instrumental in making sure that Weston Sampson was not successful on that preliminary injunction. And if I crunch the numbers, I'm talking about over $750,000 right now as we speak. Never mind had we chosen them, and all the things that might have happened. And goodness knows whether the Oak Street water treatment facility would have been built at all. I also do plaintiff's work. I do plaintiff's work for towns. I successfully negotiated a settlement for over $500,000 a couple of months ago for a town that I represented, where we had an outside custodial contractor who ruined the VCT flooring. The initial insurance offer, and I put that in quotes, was approximately $100,000. We walked away in that settlement with over $500,000 for the town. So not only are we on the defensive, we're also on the offensive. I do work in 40A, I do work in 40B, I do work in 41, subdivision control laws. I do liquor licensings, I do ABCC appeals. You might remember what happened with Waxies. Waxies ended up filing an appeal in the ABCC, and interestingly enough, not only did they end up agreeing to violations in the end, but with the assistance of some pretty heavy hands here at Deutsch Williams, and others, I assure you. They admitted to certain violations, withdrew, dismissed their ABCC appeal, and paid the town $10,000. So not only are we defensive, we're also on the offense for the town. I'm familiar with Chapter 79 land acquisitions and firearms licensing. I do wetlands regulations. I practice in the state court, not only in the district court, but in the superior court. I do a lot of work in the land court. I'm very familiar with the land court judges. You have got land use issues, I'm your girl. No offense to anyone. I don't want to say my age.
Kim, I'm going to have to stop you there, and hopefully you can pick up the rest during the question and answer.
Great, thanks, Jim.
We got a long night, so.
Okay.
In the timekeeping, next person I'm going to give to somebody else because I feel horrible about doing it. So there's 5 questions, and randomly we kind of went around. So, Linda, you want to ask your first question?
Sure.
And just so you know, there's 15 minutes, so 5 questions, 2 or 3 minutes each.
Okay.
Describe the most significant litigation involving your firm as town council for a municipality. And what were the subjects of litigation, the outcomes, and your firm's contribution to the outcomes?
I think I just addressed that with Weston and Sampson. I think that comes very close to heart. I think you saved, like I said, with I'm punching the numbers, $750,000 right now. Never mind what you would have spent with the had someone else been chosen. And in terms of, I'm very proud of settling a lawsuit for 5 times what the insurance company initially offered. That wasn't even going to get close to replacing the VCT flooring in this particular town that I represent, and I consider that a very significant victory, and I know the citizens of the town really appreciated it.
Thanks, Kim.
You're welcome.
Jenny, question number 2.
Regarding commercial development, describe the breadth of your firm's role in a major commercial development on behalf of a municipality. Give specific examples describing the complexity of the project's local impacts, and then describe the outcome. Please.
I'm Rod Hoffman, and I do contracting and develop some of the development work. Development is a broad category, and so people on our team back in the office handle the zoning and that sort of thing. Let me describe one project that I'm working on now, which will give you some idea of how we try to approach things. That is, we want to dot the I's and cross the T's in the letter of the law, but we want to be creative and come up with alternatives as a way to think out of the box. And there's a trite phrases, but sometimes that's exactly the right answer. I'm working now on a project for the city of Taunton, which is and they're doing and it's not the casino. It's a solid waste management facility. Their landfill is about to close right now. They pay nothing to dump in the landfill. That's going to end shortly, and they're trying to figure out how do we do this and not take a big hit to the budget. They put out an RFP a couple years ago, and ended up ultimately sort of two different tracks. One proposal was very conventional. We bring the solid waste to town, transfer it, put it on a rail car, ship it out to a landfill in upstate New York. Easy, certainly permittable, but expensive, because now that cost, the city's cost would be $1.5 million or something, and that's not something any town, certainly not Taunton, would like to look for. An alternative proposal is some really interesting technology that takes solid waste and transforms it into gasoline. I mean, who knew? And so instead of taking solid waste and paying to dump it, you get an end product that's quite valuable, and so that the city would share in the profits. An excellent deal, but issues. It's a new technology. Will DEP approve it? How do you handle this? The permitting it's a brave new world, and so we went through sort of a parallel process, and it was quite divisive in the city council there, because you can make the case for either. It's safe. It's an economic home run, and in the middle, toward the end of this. I and the consulting engineer said, wait a second, the right answer here is not to take an either or vote now, but see if we can get the city to tell the two contractors to work together to come up with a joint proposal. And I had some ideas of how that might work. Those kinds of contracts are exempt from 30B, so you have an alternative there. And we are now in the process of those two contractors, working together to come up with a joint proposal. And that's the idea that we came up with, and it's dealing with people, who are, 2 weeks ago competitors, to try to get them to work together. It's not done yet, but all of a sudden they're getting that idea, and if it works, it's going to be an absolute home run for the city. And that's kind of, all right, let's think about this problem and how do we solve it for the benefit of the municipality, even if we have to encourage the contractors to do what they weren't intending to do. So that's my story.
Can I just add that in our proposal we list 112 different economic development projects of different kinds. That one I don't think is listed here, which would be 113. There's 112 here, any one of which we could talk 10, 15 minutes on. Successful projects that benefited the communities for which they were done.
Thank you. Question 3 with Lorraine.
When the Board of Selectmen asks you for a legal response, please explain when you think the requested advice should be in writing. When do you think a verbal response should suffice? Please state your opinion as to the difference between the two.
I guess I'll try answering that. Part of that turns on how frequently our advice ends up being on the front page of the newspaper. If we give things in writing and the next thing we know, it's in the hands of the opposing counsel, it's in the hands of the newspapers and so on, we get quite reluctant about putting things in writing. If there is due respect for the attorney-client privilege and for executive session and the like, we put in writing, we label them as Foxborough advisory opinions, and we give a number to it, and we have a book in the office of which all these opinions that we've given in writing are kept in numerical order. We give those on issues that we think have some long-term value, where the issue might come up again, that you all may want to refer to it. We suggest to our towns that you keep our opinions and you keep them in order, just the way we do, in a book, in the selectman's office. Because these tend to be things that come up over and over again. So instead of having to call every time with the same question, you can go to the opinion, and there will be something that's intended to be guidance going forward. The things that we do not put in writing generally are first quick questions and quick answers. It's an hour before a meeting. Can we change the location of the meeting? If we try to say, hold on a second, we're going to have to give you a written response on that, your meeting will have started without your being able to take the action necessary. So we will give quick answers to those questions. And there are a lot of questions that are particular, open meeting law question about is this an appropriate subject for executive session and so on, that we will field and answer quickly. If the requester, which would usually be the town manager, the way things are theoretically supposed to work, you all voted that the requests go to the town manager, and then the town manager contacts us. But in an emergency, if you're chairing a meeting and you've got to figure something out, call. He will tell us whether he wants it in writing or not, usually. And that's so that he can give it to other people.
Thank you.
Question 4 is mine. Do you give binding single-fee quotes for work on specific projects? If so, please, can you give some examples? Single-fee quotes.
I'm not sure what you mean by single fee quotes, but oftentimes I do budgets if asked for. I'm sorry. Oftentimes I do budgets for litigation expenses, and I project out what I think it's going to cost. Now, litigation is kind of a strange animal because you never know what the guy on the other side is going to do. Mm-hmm. So it's hard to be bound right into that, but I've been around long enough to know that I can give you a rough estimate on a litigation budget. Okay, and if there are I don't generally take. We have a laboring war theory, which is if we're on the side with another co-defendant or on the side with generally speaking with another co-defendant, we let them take the laboring wars. The litigation budgets are not that high, so that's how I would do that. I'm not sure how you would do it on any particular assignment that you got, but it certainly would be an estimate of hours, an estimate of tasks. An estimate of how many times we'd have to be in court, what kind of issues we see coming up, where we see the dispositive motions and that kind of thing going. And so, budgets upon request, no problem.
Okay. I'll just supplement that by saying that we've worked for 3 years under a fixed flat rate of services, and we are proposing to go back to such a system here going forward. If we have a long-term commitment from you, we can provide a flat rate going forward. That's for all the usual town council services, all lumped together, which includes education, going to town meetings, attending Board of Selectmen's meetings, doing warrants and town meetings and motions and review of bylaws, contracts, bylaws, all that kind of stuff.
Thank you. And the last question is coming from Mark.
Please tell us about the biggest mistake you've made advising a town, and when you advised the town of the mistake and how you corrected it.
Biggest mistake.
They didn't make mistakes.
It sounds so immodest.
It's good.
I can't think of
We
it.
all make mistakes.
No, but
Well, everybo's going to get the same questions, so don't feel
Right.
like you're
Yeah.
all
We're not yet.
Okay.
Right. It's all
Okay.
of them.
Did you make a mistake lately?
Don't be fresh, Paul.
30 seconds.
I don't know. It's terrible.
Oh, biggest mistake.
I honestly can't think of one, Mark. I'm not trying to be,
I'm not saying
I'm not
that.
try- I can't think of one.
I'm not thinking of anything in particular, but, when I make, my general policy with clients, if I make a mistake, I'm on the phone right away and say, wait, I went wrong on this one, and here's how we can fix it. Or, how do you want me to fix it? I'll do whatever it takes, and there's no time spared and no cost. And what I found is, admitting a mistake actually has always, the two times I've done it, it cemented a relationship because people trust me more because I'm willing to say, no, that's wrong. We have to redirect. And so, I'm not thinking. I'm not thinking of a municipal example, but I know I'm thinking in particular of a private client of mine. I told him flat out, I drafted this incorrectly, and I'll throw myself on the sword and correct it, and it won't cost you anything. And I talked to him today, and he's been a client for 25 years. Because when you're willing to say that, I found people respect that because everybody makes mistakes, and the question is, how do you deal with it? So.
Good, thank you. So we've got a few minutes left, actually right on target. So if you wanted to give a closing wrap-up statement.
The only thing I wanted to say is, litigators can't stop talking, is that I started out my career in private practice. I worked for 7 years in New England's largest litigation firm, also known as Morrison Mahoney Miller at the time. During that time, I was appointed a special town counsel, hired by the insurance company, to 65 different communities throughout the Commonwealth. Their regular town counsel wasn't chosen by the insurance company. We were chosen by the insurance company. And I briefed and argued over 60 successful dispositive motions, primarily in the federal court. I did a lot of land use takings cases. I did a lot of allegations regarding excessive use of force, et cetera, et cetera. So while I've been with Deutsch Williams since 1997 and actually met Mr. Durensis, he doesn't remember me, I don't know why, since in 1986, I did have a career before Deutsch Williams, but I've always represented municipal entities, and I consider it a feather in my cap to have been appointed a special town council for 65 different communities within the Commonwealth. That's what I was going to say before.
That's fine.
I'd just add as sort of a closing piece here. We are committed to the town of Foxborough. I love the people we've worked with. I can't say it's all been fun, but
Interesting.
it's been very interesting. Thank you for that word.
That would be the word. Yeah.
It was a little bit of a roller coaster ride this year,
For all of us.
but we are 100% committed to the town. We've demonstrated that many, many times. I'm committed to public service. You all know, we haven't gone through our backgrounds, but you all know that I hold public office and have held public office for decades. I understand what it means to hold public office. I understand the fiduciary responsibility that we all have to the people of the town. And I'm committed and enthusiastic about Foxborough. I really care.
Good. All right, on behalf of any closing?
Thank you.
No, thank you all for
Thank
coming.
you.
I appreciate the time.
Thanks, everyone.
Yeah.
Thanks. Nice to see you.
Nice to see you.
Nice to see you, Lorraine.
This is, yeah, I know, Rod, I know. Same here, Kim.
Excuse me, buddy.
Yes,
Yes, ma'am.
Could I just ask your last name again,
Yes.
please?
It's S as in Sam.
I hope we weren't
Thank you.
A-I.
the
guinea pigs when
you
A-I.
Now we're all set.
techniques.
Oh, we know we can do it in a half an hour. Funny, some people said that's way too long, other people said that's not long, so not long enough, so.
Well, with lawyers, we
Okay.
could have gone another hour.
Oh, I know, yeah.
Thank you.
Yeah, thank you very much.
Thanks.
I'm going to ask, does anyone want to take the time?
Sure.
I will. I'll do.
You want to do that?
It is Kim.
There's nothing to give you, but just
No,
start.
no, I got it. I've got, look, I've had it. All right.
How many
2
minutes?
minutes of question, bang, that's all you get. All right. Opening 10 minutes, 5 minutes.
Well, if the questions,
You get 3 minutes.
you know, some can be one.
Well, I just watch it, I'm watching the clock, so. But no, absolutely.
All right, the next one up is
Page.
Copeland page. Yep.
Gentlemen, Copeland page? Yeah.
Welcome. Thank you for coming.
I'm Len Koppelman. Nice to meet you.
Yes, I'm Jim Dallas.
Nice to meet you. Mark Rich, nice to meet you.
I'm Jim Dallas.
Jenny Capone.
Mark Rich.
Linda Walsh. Lennon. Jenny Capone.
Everything's working great.
Linda Walsh.
Everything's working great.
Yeah, if you wanted to come right up to the table and just, I guess, share the microphone, spread the microphones out.
Yep, there's 2 microphones.
Well, welcome.
Thank you.
Before you can introduce yourselves, what we did is we had 6 firms and we wanted to do a prepared statement so everyone has the same information starting. So if you bear with me, it's about a minute just to get you on the same page. On behalf of the Foxborough Board of Selectmen, I want to say thank you for your interest and effort in providing a proposal to offer town council services to our town of Foxborough. We have received your application packet and have had time to review it prior to this meeting. Tonight we are interviewing 6 firms, and we have allocated 1/2 hour to each firm. Time will be structured so we can allow ample time for our firm, for your firm, as well as the other candidates. Our standard format tonight will be as follows. You'll be given 10 minutes for an opening introduction to describe your firm's qualifications and perhaps the reasons that your firm is best suited for Foxborough needs as town council. Following your introduction, there will be a 15-minute question and answer session. Each of our 5 members will ask you one question. These questions are all the same for all of the firms. We will not ask follow-up questions, and we will use the time to listen to what you have to say. Following the Q&A session, you will be given 5 minutes at the end to offer a closing statement. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for a second follow-up interview where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed. Should the public have comments from this interview process, time will be provided at our next meeting during our citizens' input. Foxborough Cable Access TV is broadcasting this interview live for our residents at home, so if you could please speak into the microphone. Again, thank you for your time, and so with this introduction, please proceed.
Okay, I'm going to be giving us the very brief overview, and then Mark will take over. Our firm does nothing but municipal.
Okay, to the record names. He introduced himself to us, but not to the people.
Okay, if you could just go back and introduce yourself.
My name's Leonard Koppelman from Koppelman & Page, and Mark Rich, also from the firm.
Okay, thank you.
So what we do, we only do municipal law. We represent over 120 cities and towns in the Commonwealth, and we special to another 100. The effect of that for you is there's a lot of horsepower to our firm, and we don't have to recreate the wheel. We have scanned over 1 million hours of our work, and we can quickly give you answers to your questions. In other words, it's not only less expensive, it's faster. Let me give you one quick example. If you're going to build or put an addition or build a new building, whether it be a police station, a library, I see you're doing your library, we have, you can't use the AIA contracts. You do not want to use them. So what we do is we have our own set that we keep up to date. If there's new laws, we make sure ours are absolutely perfect, which they are. And you can go out and we can type in Town of Foxborough, and in 1/10 of an hour you have your bid docs, and there's nothing better than what we use. And the construction companies know our firm. And the alternative is they give you theirs, and then you have to mark it up and spend hours negotiating the stuff. So there's a lot of value to that. Now, I recognize that costs are important, and I really put together a fees and expense response sheet that I hope you'll look at carefully because I think it'll work for you. I also did an analysis this morning of our towns that were similar in size to you, and I found one town that was 75 persons away from your population, 2010 population. And we have, for the past 3 years, done their work for approximately $80,000 a year, which includes labor, out-of-pocket disbursements, and all fees for legal. It's Town of Webster, by the way. And I looked at this current year. They budget $100,000, and we have 11 months into it. So I divide the amount by 11 that we billed, and then multiply that amount by 12, and we're under that. We're about $68,000 for the year. So I think you'd find us very effective, and I'm going to turn the mic over to Mark Rich.
Thank you. Again, Mark Rich from Coleman and Page. I think I probably have about 2 minutes left after that. But
You got 7 minutes left.
Terrific. As Leonard indicated, we do all municipal work. We don't handle private work. We have a very small real estate practice that's kind of an adjunct to the municipal work. But what we do is we work very closely with all of our cities and towns, mostly towns. We have a very dynamic practice. We concentrate on the very specific issues that all towns are facing. Pretty much every town goes through very similar issues, but every town is unique, and we try to treat each town as a unique entity because clearly you have your own issues and your own concerns. And the way we work it in order to give you that personalized treatment, to give you exactly the specified information and deal with your specific issues, we assign a lead counsel for the community. That would, in this case, be me, Mark Rich. I've been practicing municipal law for over 20 years. Started off as an assistant city solicitor for the city of Everett, and wound up coming to Coleman and Page when it was time to reach out and expand my practice. And what we do is we provide lead counsel, and then behind that lead counsel we have a firm of 45 attorneys. You would have access to every one of those attorneys, all the specialists in land use, election law. We happen to have, the top elections attorney, Lauren Goldberg, who I believe works with your own town clerk, who is former chief counsel to the elections division. We have experts in litigation, land use, real estate, any of the practice areas that you come in contact with, licensing issues. We have a complete licensing department, and we pride ourselves on having experience in every area, every facet of municipal law. And what we want to make sure is that in order to provide this service to you without putting you in a position where you're seeing a different face every time or you're dealing with different people, we want to make sure that you know who your town council is, you know who your go-to person is. It's that person's responsibility, my responsibility, to then make sure that you have the specialists lined up to handle your business, but you only have to ask one person for the question. It would be then my job to make sure that you get the right answer, if not from me, from an expert in the field. But then when you come back to me, I make sure that all of your work is coordinated. I review from the communities I'm responsible for. I review every single bill, every single entry to make sure that you're getting exactly the service you want. I get copies of every opinion and every email that goes to my clients, and I make sure that I'm there for you. I don't handle trial work. I don't tie myself up in court. I have a team of experts who can do that. But if I was doing that, I wouldn't be there for you. I wouldn't be available to you 24/7. I carry my cell phone at all times. It's always on. My wife is always thrilled when we're on vacation and the phone rings. I have to take those calls because, Town Hall is 24/7. Even after your doors are closed, I know you folks get the calls. I get the calls from selectmen at all times because obviously you get the calls at all times. There are times when things come up after hours. I still remember the time when we had a Thanksgiving crisis. We had a town that was building a new field. They were all set for their big Thanksgiving Day rivalry football game, and the state wasn't going to allow them to open their new field. And I had to get on the phone with their architects and contractors and say, look, my folks are here for Thanksgiving dinner. If I have to come down and deal with your problem, it's going to be big trouble. We're opening that field, and we got that field open. But we have to be available for just those reasons. Same thing, we had a water main break right on another holiday day, and I had to go right down and meet with the DEP on a holiday. We all convened, but it happens. That's what municipalities are about. That's what we pride ourselves on. We all love what we do. We talk about having the sense of the mission. We love working for municipalities because we feel like we're wearing the white hat. We're there with you in the trenches. When you've got litigation and you've got significant issues coming up, we're there fighting right alongside you. We know that towns are principled and take principled positions, and we work with you to make sure those principles are carried forward. We also work with you when it's time to reach compromises and determine what is the best compromise on a contract contract action or a construction project to make sure the project moves forward, that it's done fairly, that you're within budget, but that you can resolve it without having extra costs and extra litigation. So we're there watching the bottom line for you. We're watching your interests, your concerns, and we make your concerns our concerns. We want to be there for you personally. We want to have our team available for you, and quite frankly, we think we have the best team in the state. We represent over a third of the state. We represent regional transit authorities. We're involved in so many different areas because we have that expertise, and we have the backup of documents that would be instantly available to you. Leonard talked about the contract documents we have, and we work very hard on those contracts so that when you do have a proposal, you have an issue coming up, we can immediately find the right document for you. We have opinion letters that we've developed over many, many years, many of which can be adapted so that you have instant availability of information, but at the same time, we don't give you cookie-cutter service. We want to tailor our service to you and your specific needs and exactly what your issues are. They become our issues. We want to just be there for you as your town council. Thank you.
Thank you. Again, we have 5 questions. They're all standard questions for all the different firms. Mark will be asking the first one.
Either one of you, Leonard or Mark. Describe the most significant litigation involving your firm as a town council for a municipality. What were the subjects of litigation, the outcome, and your firm's contributions to the outcome?
Well, we've been involved in numerous pieces of litigation. I'll think about from my perspective. I do a lot of environmental work. We had a situation where we're dealing with a major site assignment for a transfer station, would have a significant impact on the town. And one of the issues that came to us is, as we were going through the site assignment process, working with the Board of Health and working through a site assignment, we had an issue arise where the applicant could not meet one of the siting criteria. And that forced us into a situation advising the Board of Health where we had to deny that site assignment. And the applicant obtained a letter from the Department of Environmental Protection, which drafts the very regulations we were dealing with. And that applicant presented a letter saying, no, we're grandfathered. We don't have to address that piece of information under the regulations because the DEP has determined that is not required. And under the statute, that's an allowable process. We countered and said, no, you are subject to these specific regulations. They can't be waived. We went through the Superior Court all the way up to the Appeals Court and dealt with pending Supreme Judicial Court legislation on that matter. And as a result, we were able to get a favorable decision for the town that allowed the town, that supported the town's position and result in a situation where the applicant essentially had to withdraw their application and had to come back and make a significantly different approach to the town that was much more beneficial to the town, but ultimately had a significant beneficial impact. I bring that one up because that's one that I specifically handled all the way through to the Appeals Court.
Let me just add one thing, because this would be an interesting take on it. We had the case of Millbury versus Miles versus Millbury in the Superior Court for the town of Millbury, and we won the case. And there was appeal to the Appeals Court, and we lost the case. The Board of Selectmen felt they didn't want to spend any money to appeal it further to the Supreme Judicial Court. And to us, it was important because it was a zoning issue for all towns. So we said we'd do it free, and we won it in the SJC. So we care about what we do because it's important for all of our towns. We also represent one of the leading insurance companies defending towns. We have the largest, by far, defense firm in the state. In fact, we try cases in more agencies and courts in the Commonwealth than any firm, and including the Attorney General's office.
Thank you. Linda, the second question, please.
Regarding commercial development, which, we have a lot of in Foxborough, describe the breadth of your firm's role in a major commercial development on behalf of a municipality. Give specific examples describing the complexity of the project's local impacts, and then describe the outcome.
We actually get involved in a large number of commercial developments. Again, to think of one that I was involved with myself in the city of Woburn, we were involved in the Industriplex site. The fascinating thing about the Industriplex site is, as you may have seen, John Travolta's movie regarding the Woburn hazardous waste contamination, that was that site. And so we were involved as counsel to Woburn with both the city and involvement with EPA and DEP in dealing with the hazardous waste side, and also dealing with the potentially responsible parties and the trust groups to reach a development point so that that property could be reused. So we're talking about a site that was the former W.R. Grace site, that was so significantly featured in a civil action, and now is a significant operating facility where there's a Target, there are restaurants, there are a number of facilities in addition to the Anderson-Woburn train station. We got involved to make sure that the future development would be assured, that the site would be properly cleaned up, that public health and safety would be protected, and that the ground would be available and appropriately developed for commercial use, and it's become quite a development site for the city of Woburn. We also, on a regular basis, get involved with cities and towns doing, I'd say, more routine developments. Obviously, when developers come in to put in large malls and strip malls and have to do road and infrastructure work, we get involved in putting together the agreements that allow the infrastructure to go in on behalf of the city or town. Most of our towns get involved with circumstances where the developer is required to put in infrastructure improvements, lighting, electrical, and other utilities, and we get involved in putting together the very agreements that allow the infrastructure to go in and then be presented and provided directly to the town. So we make sure to protect the municipalities so that they are involved in the process to the extent of inspecting and getting the infrastructure they need, while at the same time not having the cost of having to actually do the work. So it's a benefit to the developers, it's a benefit to the municipalities, and ultimately results in a more effective use of property because there's a partnership between the municipality and the developers.
Ginny, you want to ask the third question?
When the Board of Selectmen asks you for a legal response, please explain when you think the requested advice should be in writing. When do you think a verbal response should suffice? And please state your opinion as to the difference between the two.
That's actually an excellent question. We obviously are faced now with three options. We've got the verbal request, we have the written request, and then the email request, which is somewhere between the two. And what we've found is generally an oral response is not a very effective tool because it's very hard to capture a recollection of what someone said. You ask a question. There are detailed circumstances that go behind the question, and when you get a verbal answer, very often the nuances can be lost when that's translated before a board such as yourself. It's important, just as you meet under the open meeting law, it's important that you have documentation in front of you. When we write opinions, we always back it up. We have a very specific format on how we write our opinions that specify the question, the circumstances behind the question, then restate the question and provide you with the answer. And in my opinion, a formal letter is required anytime there is a significant fact pattern that has to be developed and explained. If it's simply a question of, is this kind of contract subject to bidding, or is this kind of project subject to the prevailing wage law, a brief email response, a very brief response can be provided. And in that case, an oral response might be appropriate. But anytime you have a fact pattern that relies upon, this action occurred, subsequent to that, something else happened. It could be a dispute with a contractor where there are a number of change orders involved in a project, and have you reached a point where there's a breach of a contract and the contractor has been called in, whether to access a performance bond. There are a number of factors, or interpreting a zoning bylaw as an example, where you have to go through the facts of the use of the property, any changes in use, expansions in use. Anytime that there are facts that have to be developed In my opinion, that should be reduced to writing so that you have that in front of you and you can rely upon that. If I put it in writing, I stand behind it. If I give you an oral, I've heard too many times my own words repeated back to me, and they're slightly off. And that slight change can change the entire tenor of the opinion. And I wouldn't want you sitting at this table, especially if you have a meeting where an attorney is not present and you're trying to rely on opinion, and if you get it slightly wrong, then you don't look good and I don't look good, and my job is to make you look good. And the best way I can do that is to provide a written opinion before you that then goes on to the public record. It's part of the public document so that anybody could see it, and it's beneficial to you, it's beneficial to the public at large. So generally, my preference is to put something in writing, to sign it, and then you could rely upon it.
Thanks, Mark.
Do you give binding single-fee quotes for work on specific projects? If so, please give some examples.
It's always hard, because all you can do is estimate, and we have a lot of experience, but you have to deal with the other side and the issues that are there. So we'll give you a best estimate, but I thought the way we've put this thing together, I think you would avoid those problems under our concept. And by the way, it was the lower of time, because we wanted to have the town to have some skin in the game to the extent that we don't get the what-if questions.
But that being said, there are a number of times when municipalities, and obviously the bottom line is a very sensitive issue, have to know what a project's going to cost. And even as an example, today I got an email from one of my town administrators outlining a project that we've been involved with. It has to do with the Community Preservation Act project, large piece of property, and whether the town, in developing this property, will be able to clear-cut that property. There are Conservation Commission implications. We've written several opinions on this. There have been fights back and forth with opposition groups as to whether the town can proceed with this. And now they're at the point where they're going back again. The town is the applicant before its own Conservation Commission. And the town administrator specified, I'm going to give you authorization to do this many meetings. I'd like to know a quote. How much will it cost me to have you go to these meetings and provide the backup? And I will sit down and review, and we have a very good handle on how long these meetings generally go. We can estimate the length of the meeting. We can estimate, looking at the issue, what the research time will be, and what will be required to put together any further opinions, and we will develop an appropriate cost estimate for that. And then, if we give a cost estimate, we will stick by it. It's generally our preference to give you the benefit of the hourly rate, because generally we're going to watch our bottom line as well. We're not going to try to generate work just to reach the point of some quote. If we quote you something and we can do it for less, we're going to do it for less. I'm going to bill you less. We're never going to work up to a quote.
And by the way, we do give quotes on litigation, but there's really two things you need to know. One, what's the likelihood of success, and then what it'll take to get there.
Thank you.
Welcome.
Okay, and the final question. Please tell us about a mistake you made in advising a town, how you notified the town of the mistake, and how you corrected it.
It's okay.
That's a tough one.
That is a tough one, and usually I know that we've been involved in a number of situations. Generally, it's a shifting of fact patterns, and we have been involved in situations where a town has gone into a project. And we've advised them. The best example I could think of is with respect to the public bidding process and determining what's the appropriate threshold for a bidding process. The reality is, unfortunately, it's usually that the project changes, and so we have to revise the advice depending on the changing of the project. In general, when an issue comes up, we work so closely with the towns that we will discuss it with them immediately and let them know that the changed circumstances have changed the aspect of the project, changed the scope of the opinion. So very often, that's why it's so important when we write these opinions to provide the facts. If we're talking about a particular piece of property and a particular zoning opinion, and that's another one where these things come up, and we specify it's our understanding. And this is a good specific one. I was dealing with a high school project, and the issue was whether that the property in the back of this high school, which we were planning on doing our addition onto, was subject to Article 97 of the Constitution, the provision that preserves property for open space and conservation purposes, and it's a perpetual restriction on the use of that property. If once it's Article 97, it's protected forever unless you get other permission from an act of the state legislature. And in this situation, based upon the information and the history of this project, we opined that this was Article 97 protected property, was not Article 97 protected property because of what we talk about, the prior use doctrine and how the property had been used previously. And we were then brought before Bill Pardee over at the Attorney General's office, who is the attorney tasked with overseeing Article 97, and he totally disagreed. And he said, I have information that shows that only a limited portion of this property was ever used for anything other than conservation purposes, and while you talk about an educational use, it really wasn't. The kids may have run down the hill, but it was always a parkland. And we worked very carefully to bring together a full argument to benefit the community, to show that it in fact was not Article 97. The problem was the Attorney General who enforces this was not willing to budge on this. And what we did, we met with this was a city mayor. We met with the mayor. We brought in the representatives from the school department and the neighborhood, and we all got together and we said, look, we can fight about this, and this will get drawn out, and we'll deal with the Attorney General's office, and it'll become a very nasty piece of litigation, because the Attorney General is already saying he's not going to go by my opinion. He's going to sue the city, and he's going to make sure this property is protected. But what we could do instead is we can put together a piece of special legislation to deal with this property only, and in it we will specify the types of uses and how we're going to balance the educational use and the open space use and wind up with a win-win for all parties. And by bringing in the neighborhood and getting the neighborhood to agree, we wound up with a win-win. The Attorney General was absolutely thrilled with what we presented. We brought it to the legislature, and it was passed. And interestingly, it was passed after that mayor lost the election, and the new mayor, who didn't like this deal, opposed it. And the legislature passed it anyway. And that was how we resolved what I wouldn't call a mistake, but what I would call is so fact-sensitive that depending on which side of the facts you looked at, and what it was our job to say to our client, you've got to recognize that the facts, you're on a knife edge on these facts. And we cautioned that from the beginning, and we can make that argument, but if instead of hanging on to that argument and standing on that knife edge, we can reach a compromise that will benefit everybody. Bring the public in, bring the opposition in, bring the state in, and to satisfy everybody. And we felt that was a terrific win, avoided litigation. It was a relatively low-cost and very high-profile victory for the community at large.
Yeah, okay. Well, 1 minute for the question and answer, right?
Yeah.
Okay. So why don't you spend 4 or 5 minutes on a closing of your choice?
Sure. Why don't I take that? Again, I've been trying throughout this, and I think these were great questions, to give you my own personal experiences. If we brought any other attorney in from our own office, they would give you a myriad of their own experiences. Each one of us has dealt with a number of different issues because we live and breathe municipal law. This is what we do. This is all we do. I've never practiced any other kind of law. I don't share my practice with private clients. We don't cross that line because we dedicate ourselves to municipal law. We do it in a cost-effective manner. We maintain our library up to date, both electronically and on paper, for those of us who still like to read. And we want to be there. We want to be the primary counsel because we feel that our mission is to provide that level of service, to provide cost-effective, efficient service that puts you on the right track. We know the law. We know the issues. And we look forward to learning the very specifics of each community and then applying what we know to what you need so that you have that specific service. We make sure, again, that we're available to you. We welcome attending your meetings. Obviously, part of the proposal includes your town meeting. We do town meetings all across the state. And we consider that the big show where we all get to go. We're before the entire community, and we want to make sure that your town meeting runs perfectly, from helping you with your warrant all the way through to the motions and then the presentation at town meeting itself, so that when you come out from your biggest activity the whole year, you feel good about that. We do this in a cost-effective manner because we've been doing it for so long, but we don't do it in a cookie-cutter manner. We do it with your specific issues and your specific concerns and interests in mind. I welcome calls, like I said, at any time, especially from each of the selectmen. I don't charge for those calls because generally you're going to be calling me saying, I've got a concern, and those are the kinds of things you should feel free to call about. But in terms of managing your legal budget, you need to make sure that there's a proper conduit, that there's a proper waste gate, essentially, to make sure that the calls that come to us have been authorized, and we only give the opinions to those people who are supposed to be asking us the questions, so that we don't get questions coming from folks that are not authorized. We make sure that the only people we talk to would be any of the selectmen pursuant to a selectman's determination of how to use town council, and through your proper channels to make sure that we give answers to the people who need the answers, and we don't squander your limited resources. Very sensitive to that. So thank you very much for your time.
Thank you, Mark.
Thanks, Mark.
Thank you, Leonard.
Thanks,
Appreciate
Leonard.
it.
Very much appreciate it.
Thank you.
Thanks, Mark. Did you do some homework on us? Because that statement was could have wrote a
Last one?
Yeah. Yes.
That's what we
Thanks,
do for all of our
Lenny.
towns.
Thank you.
Thank you. Very nice.
That wasn't my question. I didn't.
I didn't want to.
It was a good one. Thank you, Mark. Appreciate your time.
Sure, thanks. Nice to meet you. Take care.
Actually, the truth of the matter is people tell you only what they want you to hear. On those kind of questions.
Good night. Very good to meet you. Thank you both.
Hi, Leonard.
Iris and Harrington?
Yep.
Iris? Good job on the time. Interesting.
So next time you get to ask the question.
What's that?
You get to ask the question.
And I look like a hero.
Assuming they're here.
I mean,
Somebody
didn't that
came-
ring a bell when he started talking about that whole thing?
It was a very...
It was like, I was like, wow, he did his homework.
Good evening.
Hi. Come right in.
Hi, I'm Raymond Yaris.
Hi, Ray. Linda Walsh.
Hi, Jacob
Linda Walsh.
Don't want to knock that over?
All right, Jim DeVellis.
Nice to meet you.
Hi,
Hi, Chris. Jim DeVellis. Nice to meet you.
All right.
Welcome to Foxborough.
Well, thank you.
Thank you.
Before you introduce yourselves, I'm just going to give a prepared, we have 6 interviews, so we put together just a prepared 1-minute overview to get everyone on the same page.
Great.
Great.
On behalf of Foxborough Board of Selectmen, I want to say thank you for your interest and effort in providing a proposal to offer town council services to our town of Foxborough. We have received your application packet and have had time to review it prior to this meeting. Tonight we are interviewing 6 firms, and we have allocated a half hour to each firm. Time will be structured so we can allow ample time for your firm as well as the other candidates. Our standard format tonight is as follows. You will be given 10 minutes for an opening introduction to describe your firm's qualifications and perhaps the reasons that your firm is best suited for Foxborough's needs as our town council. Following your introduction, there will be a 15-minute question and answer. Each of our 5 members will ask you 1 question, and we will not ask a follow-up question on that. And we will use this time to listen. Following the question and answer, you will be given 5 minutes at the end of the session to offer a closing statement. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for a second follow-up interview where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed. Foxborough Cable Access TV is broadcasting this interview live for our residents at home, so if you could just please speak into the microphone when speaking. Again, thank you for your time, and so with this introduction, welcome, and please proceed.
Okay, thank you very much.
James?
Yep.
We lost Pauline for a minute.
Okay. Bear with us, the note keeper.
Can't proceed without the note keeper.
Yeah, it's important.
We can only talk about the weather.
Yeah.
Which is not quite hot yet, but it feels like maybe it's about to turn.
Yeah, it is. It is. Tomorrow will be a new day.
Okay, Pauline's back, so if, that's fine. So if, I know you introduced yourselves on the way in, but for the record, if you could just introduce your name.
Sure. My name is Ray Miaris. I am the founding partner of Miaris and Harrington, and with me is my partner, Christopher Heap, who is the mainstay of our land use practice in our firm. We are a firm of 6 lawyers practicing in Belmont, and we devote ourselves exclusively to municipal law. We are currently serving as town council in the towns of Hopkinton, Littleton, and Stockbridge. We don't do anything else except municipal law, and we think that we are uniquely positioned to assist your town because of that fact. And that is to say, when you are interviewing candidates for town council, an important question to ask is not, is this a big firm or is this a small firm, but how many lawyers will be working for this town and how many other towns are they working for? So we have 6 lawyers working for 3 towns. With Foxborough, it would be 4 towns. That's 1.5 lawyers per town. I think you might note in some of our competitors that they're stretched a lot thinner than that. We don't think that's a good thing for the town. We want you to understand that because of our size and because of the unique relationship with the town council, that you will be a very important client of our firm. It's easy to get lost in a bigger firm, but you don't want a firm that's too small that will not have a range of expertise. Each one of our staff attorneys has areas of specialization that they concentrate their practice on. But one thing that we do that's different from most other firms is that we meet together every day at noontime for lunch, and use that time to share what's going on with our various clients, issues that have come up in the course of the day, problems that need input from more than one person, so that we function truly as a team. Everybody pretty much knows what everybody else is doing, and when necessary needs to be brought in, can get up to speed pretty quickly because they've already heard the basics of it at one of our staff meetings. That means that you're never going to get a phone call from somebody who doesn't know anything about your town or doesn't know anything about your particular problem, because the lawyer that you thought you were going to get is, not available. If much as I like to say I'm always available 24/7, it is true that I do occasionally have to do other things. And when I'm not available, you can be sure that the person that you're talking to in my stead actually knows what's going on in your town. So it's important to know when you're dealing with a firm how many lawyers are serving how many towns and how many of those lawyers are actually involved in what you're doing. And I think we may be unique in that regard. The other thing I think that we took a chance, are aware that we applied the first round even though we didn't qualify. And the reason we did that is because we think we have special expertise in dealing with large development projects and with large, important town residents, corporate residents. The Hopkinton is the world headquarters for EMC Corporation, which is a Fortune 500 corporation, and is also currently undergoing a redevelopment of the Weston Nurseries property into a little over 900-acre mixed-use development. Stockbridge is the home of Tanglewood, the Boston Symphony Orchestra's a major concert facility that brings rather large crowds into town during the summer months. Littleton is the home of the regional headquarters for IBM. Recently took over some property in Littleton, but we've also been involved, hired as special counsel for dealing with a number of large development projects that that needed somebody to deal forthrightly with development plans. And so when we saw your RFP, we said, well, we'll take a chance. Maybe they'll be interested enough to have us come in, even though we don't meet their minimum qualifications. So thank you for doing that. We think we offer something unique in that area, and we hope we were able to convey that in the materials that we provided to you. As I say, our attorneys all specialize in specific areas, and the reason I asked Chris to join us today is because Chris came to our firm after clerking at the land court and is the zoning and land use guru of our firm, I know that land use concerns are something that is of a particular concern to you, and so I thought it might be appropriate to bring him in. We would be ready to serve you as soon as you're ready to have us. We think we would be a great contributor to your town, and we hope that we make it through this round and get invited back.
Great. Thank you, Raymond. Just one clarification for the people that are listening from home. When you say you don't meet our minimum qualifications, you actually do. We republish the
That's right.
bids,
We did.
so
I meant to
you're
say
sitting here meeting all of our requirements.
That's right. We did not meet him
Initially,
the first time.
yep,
First
and then
time
went out
through.
to rebid. Correct.
That's right.
Okay, so we're gonna offer 5 questions. 15 minutes, so 5 questions, about 2 or 3 minutes
Sure.
each. Question 1: describe the most significant litigation involving your firm as town counsel for a municipality. What were the subjects of the litigation, the outcomes, and your firm's contribution to the outcomes?
Okay.
If you're
Well, it's
allowed-
hard to say.
If you're allowed to.
No, I think I can. I'd say that well, it's hard to say which is the most, but for this purpose, I will talk about the ANP, American National Power Bellingham litigation that we undertook on behalf of the town of Franklin. Number of years ago, Massachusetts had electric utility deregulation, and there were a spate of power plant proposals in a number of different towns around the Commonwealth. I was contacted by the town council of Franklin and asked if would I be willing to serve as special town council with respect to this. And I said, sure, I'd be willing to do that. When does the hearing start? And he said, oh, it started this morning. So this was an administrative hearing before the Energy Facilities Siting Board. And so the first few days, I have to admit, I was treading water as I was attempting to read the massive amounts of material and ask reasonably intelligent questions. But as we went along, it seemed to be better. Ultimately, the facility was approved, and the town of Franklin appealed, and that appeal goes directly to the Supreme Judicial Court. So we argued the case before the Supreme Judicial Court, and based on the oral arguments, A&P decided that the better part of discretion was the better part of valor, and offered the town $7 million to drop its opposition. Now, understand, this is a facility that is well over the town line in Bellingham. It's not in Franklin at all. While the town was principally concerned about the air pollution blowing into the town, the scientific studies really were quite clear that those concerns were not nearly as important as the town had originally thought. Our own experts had come to that conclusion. But so really, we were just now talking about traffic impacts. And we ultimately negotiated an agreement with them so that all of the traffic involving the construction, whatever, had to go around Franklin and through Medway. And we collected $7 million, which the town put aside for its open space trust fund and has used that for environmental programs. There you have it.
Poor Medway.
Well, you know, Medway actually made out pretty well as well because because their street.
You don't have to go into Medway.
We're not getting into Medway. We're not going to get to the next question. I guess this would be probably for Chris, if you described it correctly. Regarding commercial development, describe the. My wrong glasses. Describe the breadth of the firm's role in a major commercial development on behalf of the municipality. Give specific examples describing the complexity of the project, local impacts, and then describe the outcome.
It's kind of what you just went through, right?
I took his best case.
Refer to question one.
I think that was a good one. I'm commercial development on behalf of the town.
One of your clients, yeah. It doesn't have to. It can be just
your role in a commercial development.
It doesn't
project.
have to be with this firm.
Why don't you? Okay.
If you could. Hold on.
Okay. Well, let's talk about Legacy Farms in Hopkinton. This is a project that involves 940 units of residential development and 400,000 square feet of office space and 50,000 square feet of commercial retail space. And when we arrived on the scene in Hopkinton, we'd just been appointed town council, and we discovered that the developer had made a whole series of promises to a whole lot of different boards and residents and what have you, and was expecting in return for the town to adopt a proposed zoning bylaw that would have made that development permitted by right. So the deal had more or less been done when I arrived on the scene and said, that's really not going to be in the best interest of the town to do it that way. So we we entered into a long and protracted debate, ultimately creating a master plan special permit process that the developer has now gone through, gotten an approved master plan special permit, and is now going through site plan for each of the different components, site plan review of it. Chris is the principal reviewer of the various applications and provides legal support to the planning board as they go through these various permits and site plan reviews.
Thank you. Next question, Linda?
When the Board of Selectmen asks you for a legal response, please explain when you think the requested advice should be in writing, and when do you think a verbal response should suffice, and state your opinion as to the differences between the two.
Okay, easy questions can be answered easily. So when a request for an opinion comes in and it's sort of obvious what the answer needs to be, I think an on-the-spot response is sometimes adequate. We need to be able to make a judgment. A lot of times questions, most common preface is, I have a simple question for you, and often not as simple as somebody might think. But if it's truly simple, I think that often suffices. Nowadays, it's almost as fast for us to write you an email response back as to give you a verbal response. And truthfully, in most circumstances, that's what we would want to do. Even when I give a verbal response right away, I often say, do you want me to put that and follow it up with an email? Just because then you have a record of what is it that Ray said, and you've got it in front of you. So I would say whenever there is time. Sadly, there's not always time. Sometimes you get a call, in the middle of a meeting.
Right.
Does this take a 2/3 vote?
Right.
But whenever there's time, it's pretty much almost as fast for us to put things into an email. Obviously, things that are more complicated and require some research or some strategy, and we're going to put those into a formal memo. Obviously, those take longer, and we would. Present those in a written memo. But even written memos mostly get delivered to clients these days by being attached to an email.
Right.
So that's our principal way of communicating.
Thanks.
Very good. Ginny?
Do you give binding single-fee quotes for work on specific projects? If so, please give some examples.
Binding them. I'd say the answer to that is almost never. And the reason is if most projects, it's pretty difficult to know ahead of time what you're going to run into when you investigate, as well as a client believes that they are telling you everything that you need to know. We think oftentimes it turns out that there's some additional piece of information that really completely colors. So I think it would be unusual for me to say I can guarantee that I will be able to answer your question in 2 hours or 10 hours or 20 hours or whatever. And certainly with respect to litigation, it would not be reasonable to do that. So that isn't to say that we wouldn't want to be to communicate how difficult something is and how much work is involved so that we can make judgments along the way. And it wouldn't, for example, be uncommon for me to say, all right, if you want me to draft a complaint and file it in Superior Court, that's going to run you X thousand dollars. hopefully we'd come in around there. And if we didn't, we certainly would be communicating. But to say that we're going to guarantee that that there are no hidden legal issues here that are going to prove to be a stumbling block, or no facts that are going to be uncovered, I think that's doing everybody a disservice. You certainly don't want to we certainly don't want to be in a position where we can't. We feel that we don't have permission to spend the time that a particular case needs.
Very good. Thank you. And Lorraine?
Please tell us about a mistake you made in advising a town, how you notified the town of the mistake, and how you corrected it. Everybody's cracking up on this.
Nobody wants to admit to it.
Nobody wants to.
Don't ever ask me this because I never make mistakes.
The tree falls in the woods.
That's right.
I guess the answer is never.
A mistake that we made. Well, a few years ago, we had an instance where the tax title filings for the town needed to be filed by a certain deadline, and the associate in our firm miscalculated the days. And what had to happen, first of all, we had to own up to it, which is embarrassing enough, but what had to happen was they all had to be reissued. So we notified the town manager, we notified the treasurer, we assisted in getting them all reissued, and we refiled them. A lot of tax title work is a lot more tax titles get recorded than actually ever get foreclosed on. So I think the long-term impact of that was minimal, but the associate was reminded how many days are in September a number of times after that.
Okay. Thank you.
Thank you. So if you want to spend a few minutes on just a closing wrap-up statement?
Okay. Well, one of the reasons why I thought that that we might be a good match for Foxborough is that Foxborough has an interesting identity, which is to say it has two identities. It has the small New England town identity that the townspeople want to preserve, and then it has the identity as the home of a major corporation. We think it's very important for towns to understand what their identity is, and we strongly believe that each town should be able to pursue its own agenda. I mentioned before about the power plants. At the time, we were representing 4 different towns with respect to 4 different power plants, and in some cases we were actively courting the power plants, and in other cases, as in Franklin, we were fighting them. And someone asked me, how can you possibly be for a power plant in one town and against a power plant in another town? And the answer is, each community needs to decide for itself. Do I want this or do I not want this? And they ought to be able to implement it. And so our view is that we're coming here to a town that has had to make some important decisions about what its future identity is going to be, and we feel as though we've had experience both in a town like Hopkinton that is actively luring new businesses into town, and as well as the town of Stockbridge, where I was told on my first day on the job that the principal duty of town council is to freeze time. We don't basically want any kind of development there. If it's not in Norman Rockwell's paintings, we don't want it. And so each town has its own sense of what it wants, and we think it's a good match to be able to assist you in implementing your own vision for your own town.
Very good.
Thank you.
Right on time.
Hey,
Perfect.
Raymond
Do
and
our
Chris,
best.
thank you very much.
Thank you.
Thank you very much.
Let's just 5-minute recess so we can
Thank you so much.
put attitude towards it.
Thanks, Ray. That's all
I'll go this way.
Thanks very much. Nice to meet you.
Thank you.
Thanks, Raymond.
Thank you very much. Nice to meet you.
Thank you.
Thank you
Chris,
very
thank
much.
you.
Nice to meet you. Thank you very much.
Thanks, Ray. Nice
Thank
to
you.
meet you.
We're halfway through.
Mine's
You want to
even
take a
worse.
5-minute break? You been fresh for the last two?
Yeah, give half time, you know?
Frank, we're going to take a 5-minute break. We have 3 interviews left. Thanks. Thank you. And then just bear with me for a second for the people at home. We're halfway through the interviews. We've interviewed 3 firms. We've got 3 remaining, so we just came back from a break. Welcome to Foxborough.
Thank you.
Before you introduce yourself, we prepared just a 1-minute statement, just so you're on the same page with everyone else that came in, so you kind of understand what's going on. On behalf of Foxborough Board of Selectmen, I want to say thank you for your interest in providing a proposal to offer town council services to our town of Foxborough. We have received your application packet and have had time to review it prior to this meeting. Tonight we are interviewing 6 firms, and we have allocated 1/2 hour to each firm. Time will be structured so we can allow ample time for your firm as well as the other candidates. Our standard format will be as follows. You'll be given 10 minutes for an opening introduction to describe your firm's qualifications and perhaps the reasons that your firm is best suited for Foxborough's needs as our town council. Following your introduction, there will be a 15-minute question and answer session. Each of our 5 members will ask you 1 question. We will not ask follow-up questions, and we will use this time to listen. Following the Q&A session, you will be given 5 minutes at the end to offer a closing statement. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for a second interview, where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed. Foxborough Cable Access TV is broadcasting this interview live for our residents at home. So if you could please speak into the microphone and hear this too. So they're pretty good, so if you want to just kind of lean towards them. Again, thank you for your time, and so with that introduction, please proceed. Thank you.
Thank you very much. My name is Jim Toomey. I'm a partner with Murphy, Hesse, Toomey & Lehane. I have with me Brandon Moss, who's been practicing municipal law for 8 of the 9 years that he's been practicing, and Mike Mercaro, who does primarily labor, personnel, and employment type matters, and he's been doing that for 8 years. I'll tell you a little bit about our firm. We're 32 lawyers. Half of our practice is in the private sector, and the remainder is in public sector work, which encompasses representing schools. We do a large amount of special education in schools, and then the work as town council. We represent approximately 10 communities doing town council work. Our approach and the way we do this with our communities is to come in as a team. In this case, depending, and I understand the RFP included labor and personnel, but I know you have separate labor council at this point, so I'm not sure exactly how that would work. But our approach generally on just the strictly town council work is that we'd come in as a team. I'd be the lead person. Brandon would also be participating. The idea of that is you're going to have the same people. It's not a revolving door. I mean, there may be an occasion where there's some issue that someone in the office has handled and has a little more familiarity with a special particular thing. But as a general rule, we come in as a team. You see the same people. We think that's very important in terms of the consistency, stability, the service you get, and it isn't a revolving door of a different lawyer every week coming in. And that way we know what your issues are. We've developed a working relationship, and we think that's important. The things that we'd like to emphasize about our firm that we think are special is, first of all, we put a high premium on quality of our work. We have both good lawyers. We take pride in doing good lawyering. In addition to that, we have a lot of experience. You'll see the length of the time we've represented some of the clients that we've listed in our response to the IRFP. We have, in addition to the grounding and a solid grounding in municipal law, what we think is we can bring judgment to bear and experience, which really rounds out the picture in terms of giving you good advice and being able to give you an idea where things will end up and pitfalls and so forth to avoid as you go along. Because there's about 10 of us in the firm that do this kind of work, we're efficient at it. It's very unusual that there's something that we haven't handled before. We meet on a monthly basis, all of the municipal lawyers, to go over issues, to make sure that if there are new issues coming up, if there are issues that are particularly complex that someone's handling, we collaborate. That allows us to be on the cutting edge and know what's going on in the municipal law area, so we can kind of anticipate and head things off. It also allows us to be very efficient and cost effective in terms of dealing with things. We're not going to the books to look at something for the first time. We've got a good handle on what's going on. We've developed a good sense of what issues are and how issues should be handled, so we can handle them without reinventing the wheel every time, and to be very efficient and cost effective. And I think the last thing I'd like to emphasize is our commitment. We don't pick up every advertisement for a town council job and just willy-nilly apply for them. It's something we look at in terms of it as a town that we think would match up with, a town that would be a good relationship with us. We're very committed to the towns we represent. And I think one of the things that will show you that, if you look at our list of towns, there are towns: Hanover, Hingham, Danvers, Norwood, Bedford, Danvers, Milton, and Natick, all of which we've represented, many of which we've represented for over 20 years, all of which we've represented over 15 years. We take a lot of pride in that. And that's because we think we've provided good service, we've engendered the confidence of the people in those towns, and we've had a commitment to those towns. And we think we have a formula that works, that's productive, and efficient. In terms of one of the other things I think that we bring to bear is a strong appreciation for what it is to be in the public sector and to represent public boards. We recognize that you're the elected officials. You're responsible for setting the policy. That's not our job. We view our responsibility is to point out what the options are, what the pitfalls may be in going down. I mean, obviously, if we saw a board that going into something that we thought was down the wrong path, would point that out. But it's not our call to say don't do that. And so we think we bring a unique ability to work with boards, to keep them informed. We do training. We have included in our RFP a number of the kinds of things that we issue when law changes. There's been a development in the open meeting law or the ethics laws or anything else like that. So we think we can provide a full service. We think we can do it very effectively. We are willing to make this commitment, and we hope you see that that is a commitment to the town in terms of the the representation we provide, and the relationship we'd like to develop with the town. So hopefully that gives you an overview of where we are. I don't know how I did with the 10 minutes, but...
Oh, that's great. Thanks.
Good. Like we said, there's 5 questions, same questions we're asking all the firms. So Lorraine, you want to start with the first?
Okay. Describe the most significant litigation involving your firm as town council for a municipality. What were the subjects of the litigation, the outcomes, and your firm's contribution to the outcomes?
Well, there's a couple I can think of. One was a couple of years ago, we had a case in Hanover where there was a bid protest, and the Attorney General's office had ruled against the town on the bid protest. The difference in the bids was close to $1 million. We looked at the case very carefully. We really worked on it hard, and we felt that the Attorney General was taking a wrong view of the law on the issue. We went to Superior Court, and the Superior Court judge disagreed with us. We felt strongly that we were giving good advice. Ultimately, the case was picked up, was overturned in the appeals court, was taken up to the state Supreme Court. And fortunately, the client had the confidence to stay with the advice we were providing. And the end result was not only that they prevailed in terms of the decisions they made in the bid process, but also that the law was firmly established that certain judgments that had to be made in the bid process were within the town's purview. So for other towns, the precedent that was set was gave towns a great deal more flexibility in terms of a bidding process. So that's one I would pick. There's another one that Brandon was involved in fees in Attleboro.
Or actually, that was a case with Bob Mangiarotti, who's another attorney or partner in the office. But I handled a case for the town of Milton approximately 2-3 years ago, which was in federal court, where they were attempting to build a cell tower. And I see with the Foxborough Open Space Plan, a lot of communities are very cognizant of protecting views and aesthetics. And in this case, Milton borders the Blue Hills, and they were attempting to put a 140-foot cell phone tower for 5 carriers right next to the Blue Hills on an off-ramp by Exit 3. Case went as far as summary judgment, and with those cell tower cases, they're very difficult to win because it's federal preemption. The federal laws are that cell service should be everywhere, and there shouldn't be any barriers. And in that case, I was dealing with 2 boards. I was dealing with the Zoning Board and the Conservation Commission, which both on their own respective bylaws and the State Wetlands Protection Act said no, which, as far as I can tell, is the only case involving 2 boards, particularly a Conservation Commission. The federal court, approximately about a year ago, actually issued a decision upholding the decision for the Conservation Commission, for the Board of Appeals, and basically stopped at that point the construction. We're on appeal right now with the First Circuit, the Federal Appeals Court. It was argued in December, but it's actually got some good issues in terms of trying to limit the construction of cell towers.
Thank you. Second question, regarding commercial development, describe the breadth of your firm's role in a major commercial development on behalf of a municipality. Give specific examples describing the complexity of the projects, local impacts, and then describe the outcome.
Well, we represent Natick and all of the development that's gone on in the Natick area. My partner, John Flynn, was involved in the latest iteration of that, which entails the whole permitting process, access in terms of roadways, making sure that there's appropriate mitigation for the communities in terms of its impact on municipal services, in terms of neighborhood highway impact. We've handled those issues. Hanover, we represent Hanover. We have the Hanover Mall. That's gone through a number of iterations in terms of development. We have Danvers. I haven't been involved as much in Danvers, but they routinely have those issues up on Liberty Tree Mall. And so it's something we're very familiar with. Hingham, I just finished working with, on one side of town, we had the shipyard developed, which was a mixed-use development, condos, affordable housing, a theater, a number of restaurants, a Whole Foods type of store, CVS. The other side of town, we had the Derby Shops, which is a major, very successful development. So we've worked through all of those issues, both from the permitting stage and advising the boards on the permitting, and then also from the bigger issues of, are these good for the town? Is it the kind of development the town wants? Is it going to return tax revenue? Are you going to be able to limit the impacts or receive mitigation? So we've covered those issues on a number of fronts, and that's something that happens with the communities we've had. We've been able to handle that stuff.
Okay, very good. Thank you. Mark?
When the BOS asks for legal response, please explain when you think the requested advice should be in writing, when do you think it should be verbal response, should suffice, or please state your opinion as to the difference between the two.
Well, I think that's where developing that relationship becomes important. I mean, there are times when you recognize there's an issue that's important and people want to have in black and white, in a formal kind of way, all of the elements of what the facts were you looked at, what the legal issues were, the pros, the cons, the outcome. There are other times when you just really need some guidance in terms of, can we do it this way or can we do it that way? Can we do it both ways? So that's something I think that we learn to develop with the towns, because every time you need a little advice, you don't necessarily want, I mean, it takes time and therefore money to develop those formal opinions, whereas many times you don't need that. Other times you do. So that's where we develop a working relationship, and we try and get a sense of the town. We would always ask. I mean, you know, first of all, we do what we're asked to do, and we don't make those decisions. But I think as you go along and you develop that working relationship, you can say, geez, this must be something you want in writing, or is this something an email suffices, or a phone call? And we can do any of those depending on what's appropriate and what the board wants.
Very good. Thank you.
Some areas of the law, I mean, are also more susceptible to having that roadmap approach. A couple of weeks ago, I worked on something for a planning board. They were going to have an applicant come in, and there was a question about frontage and whether or not a lot was developable because it had enough or didn't have enough frontage. And so it gave them a roadmap of, this is what needs to be done to have it as a pre-existing non-conforming lot, or otherwise to get around that. And actually 2 days ago I got a fax yesterday I got a fax from the attorney for the applicant, which followed that roadmap approach, and then I assume is going to expedite the hearing for development of this parcel, which has basically been neglected for years.
Thanks, Brendan.
Thank you.
Linda.
Do you give binding single-fee quotes for work on specific projects? If so, please give some examples.
To be very frank, we typically try to avoid that. We have found that it's very difficult. More often than not, we feel we end up putting more effort into it than what we get paid for. I just finished a project where I agreed to do something, and we're standing by our commitment. But it turns out that things get more complicated as you go along than they first seem. It just, frankly, hasn't worked. Now, there are occasions when it works to our advantage and not to the clients. But we found the fairest way to do this is on an hourly rate. We feel we're efficient. If something takes longer than it should, sometimes we'll adjust our billing accordingly. We're always open to discussing, how long something we estimate it will take. If it's taking longer, are there ways, to do it better or without as much time? But in general, the fixed fee is something we've not found to work out well.
Thank you. Ginny, the last question?
Please tell us about a mistake you made in advising a town, how you notified the town of the mistake, and how you corrected it.
didn't make any
I'd like to tell you I don't
mistakes.
make mistakes. but
That's right.
I'll tell you about one I made recently. This was in Situate. The town administrator's contract was being negotiated, and she called up, she said, can we do this in executive session? And can I take the vote in executive session? I said, yes. And she said, you sure? I said, yep. And I even there was an email exchange on it. Well, about 2 months later, she picks up the Beacon and looks at a report of a case from the Attorney General's office. And as you may be aware, the open meeting law now has shifted to the Attorney General's office interpreting it. And
We're well aware of
and
that.
it becomes a little bit more restrictive than we all thought it was. So anyhow, she said, this is what it says. You told me we could do this. The decision, I think it was down in Carver, says you can't do that. So as a result, I'm trying to think now. I think maybe this might hit closer to home than I was. I think maybe there was a school committee involved in this too. But in any event, I said, gee, I read the case right away. I said, you're right. We've got to straighten this right out. So, there was no. I hadn't read the decision at the time. I mean, it was the AG's decision was like a week or 10 days of the time I gave it, but I hadn't caught it. Generally, we have someone in the firm looking at that. They hadn't caught it. I said, look, this, we're on the wrong side of this. Here's what I suggest we do. Let's post a meeting, announce what happened, re-vote it, get it done right away. The local paper has filed an open meeting complaint with the Attorney General's office. We've responded and been forthright about how we got to where we were. The local paper hasn't yet decided whether they're going to pursue the issue. But I mean, that's what you have to do, and that will happen. And not something I like to have happened, but you got to deal with it and deal with it. That's a solution.
Very good.
I
Okay.
hope people in Situate aren't watching this. You don't broadcast.
They know Foxborough is.
No Foxborough.
Had to unring
It's
the
well
bell.
covered in the paper. I don't know.
All right, thank you very much. If you want to give 5 minutes or so for closing statement, wrap
Yeah.
up.
I think we've had a good chance here just to kind of give you a flavor of our approach. Hopefully, we've been able to answer some of the questions. I think we do bring a breadth of experience, represented a number of different kinds of communities, which has exposed us and given us a lot of experience. We do feel we can establish the kind of relationship that we pride ourselves on in terms of working with the town and provide good services, quality. That's something we really put a lot of emphasis on. We're professionals at this. It's something we've chosen to do as a firm. We want to be known as doing a good job at it. We think we've succeeded in that. We encourage you to talk to some of the other towns that we've worked in. And we think we could do a good job for Foxborough, and we think it's a relationship that would be productive for both of us.
Again, thank you. Thank you
Thanks.
so
Thank
much
you
for
very
coming
much.
in, and thank you for your time. Appreciate it.
You worry it out.
Thanks, Brian.
Thanks, Jim. Appreciate it.
Thank you.
Very nice to meet you.
Nice to meet you.
Nice meeting you.
Nice
Thank you very much.
Thanks.
Thanks, Brandon. Appreciate it. Nice to meet you.
Very much.
Let's say enjoy the rest of the night, but that's probably
Almost done. Thank you. Mark just had to step out, so give us a couple minutes.
Well, he's doing pretty good at the timekeeping, I must say.
He's doing good.
Yeah.
We're on schedule.
Is Crystal here for this?
Thursday's planning board meeting.
Oh, I'm sorry?
You want to mention the planning meeting? For
Sure. There's actually 2 planning meetings coming up. Anyone that's interested from home, I'd encourage you to attend this Thursday. It's going to be at the with the planning board. They're holding their second round of public input. The first one was let's wrap our arms around the whole town and see what the desire is for the whole town: housing, business, traffic, economics. They took that input, and then this Thursday they're having round 2, which is what do we want to see around the common, around the center, the businesses. So that's Thursday. The following Thursday, that's when we're going to have our joint meeting with the planning board, and that's talking specifically on housing and 40Bs and the state process for wrapping our arms around that. So we're just waiting for one. He's coming back, so we're spinning our wheels a little bit. And thank you. Welcome to Foxborough.
Rich Bowen.
Nice to meet you, Rich.
Jay Tallerman.
Hey, nice to meet you, Jay.
Nice to meet you. Jay Tallerman.
Rich Bowen.
Nice to meet you.
Hi.
Jeannie
How
Griffiths.
are you?
Nice to meet you.
It's been a while. I did some work for him on 40B stuff, actually, ironically. Rich Bowen.
Hi, Jeannie Griffiths.
Linda Welch.
Okay, so we know who one of the competitors was.
Outside the door for a while, you've probably seen the other 4.
I talked to Ray Miaris for a while out in the parking lot.
Yeah. So, well, welcome.
Thank you.
As you may be aware, we're interviewing 6 different firms. We're doing it tonight. So I prepared just a brief 1-minute introduction just to get you on the same page with everyone else. So if you bear with me, I'll just read this, and then we'll let you introduce yourselves. On behalf of Foxborough Board of Selectmen, I want to say thank you for your interest in and effort in providing a proposal to offer town council services to our town of Foxborough. We have received your application packet and have had time prior to this meeting to review it. Tonight we are interviewing 6 firms, and we have allocated 1/2 hour to each firm. Time will be structured, and Mark's our timekeeper, so we can allow ample time for your firm as well as the other firms. Our standard format will be as follows. You'll be given 10 minutes for an opening introduction to describe your firm's qualifications and perhaps the reasons that your firm is best suited for Foxborough's needs as our town council. Following your 10-minute introduction, there will be a 15-minute question and answer session. Each of our 5 members will ask 1 question. We will not ask a follow-up question, and we will use the time just to listen. Following the question and answer session, you will be given a closing 5 minutes to offer a closing statement. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for a second follow-up interview where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed tonight. Should the public at home have comments from this interview process, time will be provided at our next meeting under citizens' input. Foxborough Cable Access TV is broadcasting this interview live for our residents at home. So if you could just speak into the microphones, and they're pretty decent microphones, so just lean towards it and it should be okay. Again, thank you for your time, and so with this introduction, please continue. Please begin.
My name's Jay Tallerman. I'm a partner with Blattman, Bobrowski & Mead. Rich Bowen, also a partner. Rich and I, we have 5 partners and 3 associates. 2 other partners who had hoped to perhaps introduce themselves to you tonight, Mark Bobrowski, who does a lot of land use and zoning work, and one of our other partners, Lisa Mead, who along with Rich and I help manage towns from the primary contact phase on down. Also works in general municipal. We have 5 total partners, 3 associates. We have kind of a partner-heavy approach. We have 1 main office in Concord, and then each of the other partners has a separate office. Well, we have 2 partners in Concord, Mark and his wife, Betty Ann, who does real estate work for us. Lisa Mead is in Newburyport, where she lives and where she has a robust practice up there. She's also a former 3-term mayor up there. Rich lives in Situate, where he's the moderator and on probably a half dozen other boards over time, and he has his office there. I live in next door in Norfolk, and I have an office over in Millis, and so in this way we're able to...
I think I live in my car.
Yeah. We're a town council in 11 towns right now, and we've been doing the town council work since about 2007 or so, and we've been special counsel where we cut our teeth for a long time, probably right now 4 or 5 dozen towns, mostly on land use matters, but on other matters as well, some tax matters. Rich, eminent domain. Rich does some special counsel work right here.
I'm your special counsel for an appellate tax board case with Anna. Okay.
Rich and I were also former partners together at Kopelman and Page, and I left Kopelman and Page in 2006 to join in the partnership with Mark Bobrowski and Lisa Mead and Betty Ann Blattman. Rich left about, I think it's a year and a half ago, 2 years ago, and we've kind of got together on the premise of doing the town council work slightly different, and I think you can see that some of that in our proposal. We, through both our billing practice and just the way we approach it, we kind of take a slightly different look at it. We kind of take a proactive approach, and that's why I think our flat fee proposals work so well. We like to work with you, get as close to that policy line as is appropriate for a lawyer to do without crossing it, and help you achieve your goals, and help work with you and identify problems before they become problems in litigation, which, in our opinion, in our experience, becomes more expensive and less productive. So we focus our efforts on training, on being there at board meetings, on helping write decisions, on giving seminars, providing office hours, and being proactive when we do it, when we represent towns. And about half of our town council towns we represent on a flat fee basis. We are there as often as you like, and as many phone calls as you like, so that you're never worried about picking up the phone because how close you are to your legal allotments. And we have found that that's worked a lot. We have flat fee arrangements in Maynard, Wareham, Douglas, Kingston, Bellingham. Easton is a slightly hybrid. And in all those towns, it's been enormously successful. We hope you take the time to call some of the town administrators in those towns and ask exactly what their experience has been with it. We think it's a winner. There are months when litigation crops up where the bear eats us, but it tends to balance out over time, and because we have so many towns now, it balances out from town to town. Obviously, litigation is the single biggest drain. But with our approach, our proactive approach, whether you use a flat fee approach or not, we've seen the litigation list go down. When I took over Kingston from my former firm in 2008, we had a laundry list of litigation. Now we have next to nothing. Rich came over and stayed as town council in Wareham. We have whittled down the litigation list to nothing. And that's been our experience throughout our towns. Now, it sometimes means that we're on site more. I loved it.
That's the best part of the job.
Everyone in our firm has been a town official. Like I said, Lisa's was a 3-term mayor. Mark Bobrowski is still on his planning board in Concord. Rich is still the moderator. I sit on the Council on Aging Bylaw Review Committee. I've been on the CPC. I still do work throughout my town on various things. So we all do a little bits and pieces of it. We understand it. We hear your pain. We feel your pain. So we feel we can identify what the problems you have. And the balance has been for us, because we like to get involved, is making sure that it's your policies, not our policies. We all know what we'd like to do in our towns, but what we've been able to forge over the last few years is to try and understand what you want. We meet the boards. We discuss things with you. We hold office hours, whatever you guys want to do. I mean, I'm the next town over. I sense a little bit of some of the things that are going on here, more than sense. I can read about a lot of it. And these are important issues. And we feel that we would probably be most interested in getting up to speed on those first, looking at your list, litigation, trying to cull through it, get to know your land use boards and your other boards, your town manager, and try and work through some of the issues so that we can be helped to avoid problems in the future, get ahead of problems. So I know I've rambled on a little bit. If Rich has something to add, Rich has a whole different, a lot of us come from a land use context. Rich has a tremendous general, eminent domain,
litigation,
tax, and litigation practice that has been a huge boon for the firm.
Yeah. Well, thank you for saying that.
Yeah.
Well, just by way of background, I've walked the mile in your shoes. I was a 2-term selectman in the town of Scituate from 1983 to 1989. I'm Scituate's, I think this is my 9th term as moderator. So I'm very familiar with how town meeting works and its ins and outs and the high points and the low points. As Jay said, he and I had worked together at another firm, which we won't name. And
I named it.
Oh, that's right.
Did.
Well,
Yeah. You let the
you
cat
let the cat out of the bag. And for me, one of the reasons for the change was the opportunity to practice law in a different way, in a much more satisfying way. The toughest thing for me about the way law is traditionally practiced in the town council field is that your lawyer almost becomes your enemy. When the lawyer walks in the door, the first thing you do is you look at your watch, and you get worried about how long your lawyer is going to be there, and sometimes that worry overcomes the real need for having the lawyer there. I don't think that worry serves you well, and just speaking personally, I never found it very satisfying. I don't like to meet with a client and to always have that, below the surface feeling that somehow I'm the enemy, because in the background, in your mind, you're hearing tick, tick, tick. And I think that's the beauty of what Jay and my colleagues have developed in terms of the flat fee. When we come, we're not the enemy. We're there to help. And as someone who has walked the mile in your shoes, I'm happy to say that I, along with Jay and the other members, can bring that kind of experience to you. And when you need us, we're there. Now, I love doing office hours because I want to be part of the team. I want to know what you think. I want to be able to help you accomplish what it is you want to accomplish. And if I'm just a regular guy that you can talk to about things and bounce ideas off of in a context where you don't have to worry about how much it's costing you to do that, I think that's to your benefit. Truly the best thing about what we're doing are the office hours. I just think it's fantastic.
And we structure that in a whole bunch of different ways, and different boards of selectmen and different administrators or managers want us once a month or as needed. We do it differently in the different towns. It's been really helpful, especially on the land use front. Sometimes a DPW guy can't get away. He needs to work on a project, needs me to look at a contract, this and that. It has been really helpful. It's not for everyone, but for the most of our towns, we do it.
You can bang out a contract while you're right there.
I meet with the planners. I do site visits on my office hours.
Here comes that civil rights complaint that's just walked in your door, and you can say, well, do you really want to be doing that? Because here's what might happen. Well, guess what? You didn't do it. You didn't get the civil rights lawsuit.
I assume that's
it's
about
different.
10 minutes there, if not a little over.
Right on the dot. That's fine. So as we had said, thank you for that. We have 5 questions. Ginny, you want to start it off?
Describe the most significant litigation involving your firm as town council for a municipality. What were the subjects of the litigation, the outcomes, and your firm's contribution to the outcomes?
Oh boy, we both have big, lengthy lists. For me, I'm just going to reel off the most recent one that I think was significant. Is actually not even in my usual practice area. I do a tremendous amount of 40B work, 40A work, and wetlands work, and I have some, occasionally when you get a nice 40B win, that's great, and I've had those. But the most significant one is one of more recent vintage that I had in actually at the Appellate Tax Board, which is not a place I always practice, where the town of Situate, actually Rich's hometown, hired me to work on a tax dispute involving a closed church. The archdiocese closed a church, and there was an active vigil in the church, so they hadn't sold it, but they did want to sell it. When they closed it, the town started taxing them. They weren't using it as a church anymore, and the church fought that, and they fought it for years. And the town, it's a $3 million waterfront property, so we're not talking about something that's hidden away anywhere. So it was a significant amount of tax dollars. And they pushed and they pushed, and they gave me my marching orders to stay on it, and it was new law, and it was followed essentially throughout the, to the extent that people follow such small issues throughout the United States, because churches are exempt everywhere. And we were able to essentially create a line of arguments that is now being used to help municipalities that are similarly situated in Massachusetts as well as elsewhere. It was a pretty significant case.
I think, what have I got? Well, I'm happy to say that in the last year and a half, I've been more in the position of heading off litigation rather than litigating the heck out of things, which I think is probably the way you want to be. But that being said, I did have kind of an interesting case about a year ago called Woburn versus Sprint Spectrum, an appeals court case. And in that case, Sprint had transferred all of its assets to a captive Delaware corporation for $1 and then leased it back to Sprint in an effort to evade local property taxation. And I was representing the city of Woburn. And the city of Woburn stood to gain, just for the period in controversy, about $600,000 if I won the case. So using the sham corporate doctrine, I was able to convince the appeals court that this was a bogus transfer, that this was a captive corporation, and I'm happy to say that Woburn got $600,000 and will continue to get sizable property payment for this property. So I've had a number of construction cases. As you probably know, with construction cases on building projects, those are usually won in the preliminary rounds where you have an unsuccessful bidder. They go for an injunction. If you lose at the injunctive level, the project grinds to a halt, and you're usually in a rebid situation. And I'm happy to say that so far I've managed to prevail on all of these injunctive relief cases, and we've got school building projects going up and lots of great things.
I thought Rich was going to mention he's done a lot of adult entertainment cases that
I
are
don't like to
novel
talk
and
about
unique.
that.
We both have. Yeah, they're less for television, I suppose. But
I've never actually been able to, in doing these cases, I once had a judge who said, "Oh, great! I've always wanted one of these cases. I want to go on a View." And it was like, really? No, I had one case.
I just woke up Foxborough.
Yeah. Well, I'm happy to say I've had one that went all the way to the Supreme Court, and certiorari was denied, and we were able to prevent a strip club from.
Those are difficult
moving to
cases
town.
too. We've both had
Yeah.
to deal with that. It's a combination of zoning and civil rights that some of our biggest challenges.
Yeah, the strip club people tried to hire me for their next case. I said, no, thank you.
On that note, question number.
Right. So regarding commercial development, describe the breadth of your firm's role in a major commercial development on behalf of a municipality. Give specific examples describing the complexity of the project's local impacts, and then describe the outcome.
Sure. I'm quite confident to say that dollar for dollar, pound for pound, we stack up against anybody. My partner, Mark Bobrowski, is the development guy. He literally wrote the book that is on your bookshelf here in your planning offices on zoning and land use and planning law. He did the Legacy Place project, all the permits, massive development agreements, which contain massive mitigation agreements for the town that brought monies in and had so many assurances. I did
Did very well out of that.
Yeah. I did all the permits for what will be a humongous tenfold expansion of Mashpee Commons when it arrives, which includes not only hundreds and hundreds of thousands of square feet of new commercial, but also 480 units of housing, creating a new town center, worked with designers throughout, and 15% of that housing is going to be affordable housing. It was a mix of 6 or 7 different permits. I worked on the Kingston 40R. They're not moving forward now, but to develop the permitting for all of those, again, the biggest Chapter 40R project in Massachusetts if it goes forward. And we had to litigate that in 3 different forms all the way up to the SJC. We won each and every piece of that, and that that awaits a certain amount of permitting. We have permitted more wind turbines, I believe. My partner, Lisa Mead, has become essentially the go-to specialist for permitting of wind turbines and solar facilities throughout Massachusetts.
Drive down Route 3 through Kingston, and you
Yep,
can see
those are
four
all
of them.
ours. She has been able to negotiate the type of agreements that get direct streams of monies to towns, whereas in a lot of these, the money flows more to the private provider of wind. Boy, it goes on and on. We have a list in our materials. We have worked on more than 3/4 of all Chapter 40B projects in the state between Mark and myself. I don't think there's anyone who's litigated more, worked on cooperative permits for, or done develop agreements more. I'm working on a development agreement for WS right now in the town of Bellingham, where I'm town council, that will create a new on-ramp, off-ramp. The list goes on and on and on. Mark is working constantly. He did the big project up in Haverhill to turn all that old vacant mill space into viable, affordable, and market-rate housing, complete renovations. I did a similar project in Watertown that took unused, blighted space, cleaned it up, and got it redone as a mix of housing and urban infill that provided retail and shops. So I don't think anyone's done more than we've done in that. I know I'm missing some that are in our list, but we're doing that every day as special counsel if we're not doing it as town council.
I usually do the TIF stuff.
Mm-hmm.
Yeah. So
I don't think we've ever had a TIF in Foxborough, though.
We tried that.
We tried. Yeah. All right, question 3. How are we doing on time, Mark?
You got 10 minutes.
When the Board of Selectmen asks for a legal response, please explain when you think the requested advice should be in writing. When do you think a verbal response should suffice? And please state your opinion as to the difference between the two.
Well, it's interesting you say, and I'll let Rich decide too. So much, it's really so changed in terms of giving advice and providing opinions. When we started giving opinions to council, to towns as town council, it was always in writing. It was on the letterhead. It was in such and such a form. Email has changed that drastically.
Mm-hmm.
Sometimes it depends upon what the town wants and what they need. For example, I work very closely with the town administrators in Easton and Bellingham, where I'm talking to them every day, and I'll get a quickie from them. Tell me how do I change this zoning bylaw? And that's an email. When there's an issue that affects liability, and I think Rich probably follows the same thing, I'll say, this seems like one you want in writing. You want this in writing. Sometimes there's a good reason not to have something in writing as well.
If it's going to be really bad, you might hear us say, oh, no, you don't want that in writing.
But, and not so much bad from the standpoint of bad news, but bad from the standpoint that if we have to give an opinion that could necessarily become a public record, we want to make sure that we're going down a road. So we'll try and work through a verbal first and then say, this is a weighty matter. Is this something you'd like in a formal opinion or not? But we generally look to the towns, and it's all stripes, it's all shapes and sizes as to what people want. But I think the weightier the issue, the more I lean towards a written. Day to day, I'm issuing 15, 20 little bits and pieces of legal advice. Those are email, those are on the phone, an occasional text here and there if that's the way they communicate with me. It's the bigger stuff where we go in. And then there's the office hours, too, where we're sitting down with someone and working it out just like we are right now.
But a lot of it comes down to what policy do you have in place. Some boards are very structured. All contact with council must go through the chairman. Okay? Yep. And in other towns, it's, free-for-all. It's up to you to tell us what you want, and we'll deliver.
Mark, next question. Thank you.
Do you give binding single free quotes for work on a specific project? If so, please give some examples.
On specific projects?
Say we were going into litigation, would you give a quote on a litigation per se?
Well, sure. In fact, I've done that for a few towns. Now, looking at our fee and expense thing, we give 2 flat fee proposals. The first is all in. That's your advice, that's attending meetings, that's office hours, and that's most forms of litigation. I have been doing this flat fee stuff now for 5 years, and I've had one excluded case from it. So it's almost all gone through the flat fee, so there's been no need to have a binding cost. But for other towns that are cash-strapped, where for example, I serve as special counsel, so I was doing something for the town of Brookline, a 40B case, and we took it up to a certain point, and they were stressed with their legal budget. They wanted to take it another step. They were concerned about taking it to this certain level of appeal. What would that look like for them? And I said, I tell you what, I know I've done enough of these types of cases so I can measure it. I'm going to do, and I developed a fee with them. We talked about it where they're at certain milestones, there was a certain payment predetermined coming in. And I have to bear some of the risk in case there's a curveball from opposing counsel, but we do enough of it so that we have a good feel for it. Sometimes for the towns where we don't have a flat fee or where we have the partial flat fee, which is our proposal number 2, we will box litigation off or specific projects off. Then there's my partner, Mark Bobrowski, who will rewrite your zoning for you. As part of our flat fees, we do zoning bylaws routinely in your annual spring or your special fall town meetings or whatever. That's part of the fee. But sometimes you want to chuck it all out the window and start anew. That's one of Mark's primary specialties. He does that with a boxed fee, where he's done it. He'll look around your town, he'll see what the needs are, he'll look at your current zoning code, he'll talk to the planner, and he'll develop a fee. So we've been successful doing that. I think the flat fee is the way we've gone more so along those same lines of kind of capitalizing on certainty. But we've worked out fees in all different kinds of contexts from trials. I've done it for trials. I've done it for specific 40B projects at the permitting stage as well.
We've talked so much about this flat fee. I didn't want to give a follow-up question, but it kind of relates to the same question. Could you tell the town what it is so I don't have to dig it up?
Sure. Well, we do in our fee proposal, we have a 3-level or 3-tier proposal. The first proposal is $6,500 a month. And that is, you get everything. That's the Cadillac. The things that we don't do labor law, as you know, and generally tax title work, mundane tax title work, we don't do either. That's normally handled through a separate fund. Everything else is done. We'll come to your meetings. Now, it says 3 meetings a month with your boards. Some months that's 4 meetings, some months it's 2. I never charge someone for that 4th meeting. I don't intend to start. It handles attendance and preparation for your town meetings. It handles writing decisions, helping you craft bylaws, all of the opinions across the board, all of the selectmen's licensing hearings if necessary, all the office hours, and all the land use litigation that you can eat, so to speak. All of that. It excludes non-insurable things that kind of run outside general bylaw enforcement. Again, I've seen it happen once in 5 years in all of our towns where something fell outside of insurance and outside of our flat fee. So that's the first one. That's $6,500, all access, all the time, pick up the phone whenever you want. The second tier is a $5,000 animal. That's $5,000 a month. That's everything but litigation. So that's full access, board attendance, board drafting, everything we just talked about with the exception of litigation. That you pay our hourly rate for. A couple towns have done that more, have opted for the full flat fee. Town of Maynard does the more of the modified. Their litigation, that they felt they had a good grip on it, and it's worked out well for them. So there are some towns that do that. The reason, if you have a low litigation count, great, but one piece of Superior Court litigation, even on a mundane zoning case, can be $25,000, and that's a big chunk out of your annual legal budget. The third tier is just a straight hourly, similar to what you've seen elsewhere. We still try and be as proactive as possible under that scheme, but it is a straight hourly, and some towns just want to keep doing it that way.
Okay, just enough time for one more.
We've got about 4 more minutes, so one more question, and then your closing. Linda.
Please tell us a mistake you made in advising a town and how you notified the town of the mistake and how you corrected it. Tough one, I know, guys, but
yeah,
someone had to ask it, and it had to be me.
I don't think in terms of kind of recent experience, I can't recall a mistake we've had in a piece of litigation. I have given perhaps incorrect advice on, say, a zoning matter to a board or in drafting a decision, and I just cop to it and say, let's move forward from here. I'm pleased to say that it's few and far between, and we've never had to have anyone resort to our malpractice carrier, and we've never done anything in terms of a mistake that's resulted in litigation or anything else like that, or irreversible damage. Comes along lines, sometimes we give an opinion on something, and then another attorney will say, but you missed this.
Right.
We have to cop to it.
Right.
And there's only one way to do it. And that's to say it. I don't know what Rich's experiences are.
I'll throw one out. I was doing a town meeting a couple of years ago, and there was a proposal, a bylaw amendment that would have changed the zoning bylaw. And a question came up as to whether a current applicant would be grandfathered, not if the bylaw was changed. And so I asked the planner, when the hearing dates were and how far along things were. And the planner gave me some information that seemed a little quizzical to me, but the gist of it was that the person was far enough along that this party would have been grandfathered.
Rich, I'm going to interrupt you. I'm going to give you the option of finishing this thought or doing your closing, because I'm trying to keep everybody on the same 30 minutes.
I'll finish quick because it ended happily.
Okay.
I checked with, so it didn't sit right with me. I researched the information over the weekend between the town meeting, and at the next session of town meeting, I asked the moderator for the mic. I asked somebody to reconsider the article, that I learned this information, that if people had voted in a particular way based on my opinion on the night before, they should re-vote it. I copped to it, and people said thank you very much, and they voted the same way that they did on the first night. But if you see a problem, you gotta jump on it.
Absolutely. Yeah. Thanks.
Good, thank you. And we'll give you, only because we're at the end, 1 minute.
Okay.
You asked to follow up, so. 1 minute.
Blame it on Mark.
Always do.
One thing I wanted to say about the way we've also structured this one, and it's slightly unique. Rich has a pre-existing relationship doing work for the town, so I thought it would be good for him to be kind of labeled as the primary contact person. I have a very local presence, though. We both manage a few different towns. So we're kind of proposing kind of almost a dual. So where you'd have access to either of us. We actually do that in some of our other towns. So we're not that either of us have the time to do it, but there are times when I'm just closer. It's just easier. And I also do more land use, and Rich probably does a little bit more town meeting and a little bit more finance stuff. So we really are kind of presenting it as a double primary. Now, every administrator and every board of selectmen wants to structure it differently, and we're receptive, but we think it's a kind of a unique way given my proximity. Literally took me 7 minutes to get here this morning.
Took me 40. I'll say, if you want somebody who's going to get down in the trenches with you, and I don't know what you want or what sort of counsel you're looking for, but if you're looking for somebody who wants to get down in the trenches with you and help carry your burden, and who's going to be there with you, and who probably burn a hole in his stomach, along with the hole you're burning in your stomach, we're your guys.
Rich and Jay, thank you very much.
Thank you,
Appreciate
Dennis.
it.
Thanks very much.
Thanks.
Pleasure.
Thanks.
Thank you.
Thank you very much. Thank you.
Thanks very much.
Jay, nice to meet you. Nice to meet you.
Thanks.
Thank you very much. Nice meeting you.
Oh, she left already, didn't she? She was going to stay to a certain, why don't we? She was going to leave right after the came in. Just lock up for her. Let her know. Walk.
I don't even have my notes with me. We're just going to be chatting. Yeah.
I hated to close them off, but
No, but it would be nice before we make the final. Oh, can I talk?
Yeah.
Before we make the, before we make the final Judgment.
Ranking.
It'd be nice if we could go back and read these things over again, because I had notes. I have notes on my thing,
Read what over again, the packages?
the packages.
Oh, yeah, sure.
Only because, okay, you read the packages, you talk to these people.
Right.
I want to read those packages again.
Okay.
Yeah.
You know, so before we make the final.
Yep, yep.
Jimmy,
Well,
you were saying?
Hi.
Hi, good to see you. Nice to see you. Mike Cabral. Hi.
Mike Cabral.
Good to see you. How you doing?
Hi, Mike Cabral. Nice to meet you.
Hi, Mike. How you doing? Jimmy Cole.
Hi, Mike. Nice to meet you.
Nice to meet you.
Well, welcome, Richard and Mike.
Thank you. Good to see you. Thank you.
If you bear with us for a second, I'm going to read a quick one-page introduction to kind of get you on the same page as everybody else. It's the same thing that we read to all the six out of the six candidates. And just so people, the reason that you're six is not because of any other reason that your package came in sixth.
Okay.
First package came in first, so that's how we did it. On behalf of Foxborough Board of Selectmen, I want to say thank you for your interest and effort in providing a proposal to offer town council services to our town of Foxborough. We have received your application packet and have had the time to review it before this meeting. Tonight we are interviewing 6 firms, and we have allocated a half hour each to each firm. Time will be structured so we can allow ample time for your firm as well as the other candidates. Our standard format is as follows. You will be given 10 minutes for an opening introduction to describe your firm's qualification and perhaps the reasons that your firm is best suited for Foxborough's needs as town council. Following your introduction, the 10-minute introduction, there will be a 15-minute question and answer session. Each of our 5 members will ask you one question, and there will not be a follow-up question. We will use the time to listen. Following the question and answer session, you will be given 5 minutes at the end to offer a closing statement, which brings us up to the 30 minutes. Following tonight's interview, our board will convene before we leave tonight and decide which firm or firms to invite back for the second follow-up interview, where we can discuss the possibility of an agreement in more detail. This is a public meeting, however, public participation will not be allowed. Should the public have comments from this interview process, time will be provided at the next Citizens Input next week. Foxborough Cable Access TV is broadcasting this live for the residents at home, so if you could speak towards the microphone, it's appreciated. So again, thank you for your time, and with that introduction, welcome, and please proceed.
Thank you, Jim. Good to see you. I know I've served for all of you in the past.
Richard, can I just ask you, just for the record, if you could just say your name and also yours?
I'm Dick Gellerman. This is my partner, Mike Cabral. I didn't think I'd spend a lot of time talking about who I am. I think most of you know that. But I did want to talk about, briefly, to bring you up to date on my experience, other than having served as counsel for Foxborough for 30 years. I've also been town council in Sharon for 24 years, continuously up to the present time. I've served as a special town council in 5 communities over the years, Mansfield, Rentham, and others. Because of that extensive municipal experience, I've also represented private companies and individuals in governmental law, permitting, development, and issues like that. In the past, I've served as chairman of the Public Law Section of the Mass Bar Association, chairman of the Municipal Law Committee of the Mass Bar Association. I've authored several legal treatises on different areas of the law. I've lectured for the Bar Association. My law firm, Mike and I, our law firm consists of 4 attorneys. Mike will tell you about his own experience, but the 2 full-time associates that we have are Lisa Whalen, and some of you have worked with Lisa. She has 16 years of practice. She started out 2.5 years at the land court, which does a lot of governmental work, as you know, that the land courts, the zoning, and planning location for many cases. After that, she spent 2 years with a Boston law firm in municipal law, and she has been with me for 12 years, including 4 or 5 years when she was living in Vermont and worked with us through our server. She's been back in this area for 4 or 5 years now, and she does a lot of her time is spent for Sharon's position. She does a lot of zoning, planning, open meeting work, and I'd say about 80% of her time is spent on governmental law. Our other full-time associate has been an attorney for 29 years. She was the planning director in Dover. She's been with our law firm for about 5 years. Probably spends maybe half her time in governmental law. Mike, why don't you just tell your experience, and we'll go back to what our law firm does.
Sure. So, after also working at the land court and clerking for the judges of the probate court, I went on to work for a municipal law firm for 2 years as well, where my main practice, not only general municipal law, but focusing on land use and real estate litigation, representing zoning boards, planning boards, conservation commissions, working with building inspectors on a regular basis, and litigating many cases not only in the land court but Superior Court, other courts as well, before the Building Code Board of Appeals, and in some jurisdictions in Massachusetts, the Housing Court as well. After 2 years at that municipal law firm, went to open my own practice where I focused on real estate land use law as well, working with private parties before local boards and working with commercial real estate developers. After Dick and I partnered up as well, my practice remained close to the same, but taking on more municipal law work as well, continuing to work with private developers on commercial projects, but focusing mainly on the land use, the litigation still, and the real estate aspects.
So we are, essentially a very experienced municipal law firm, but that maybe some of you don't know this, but that is not all that I've done in my career. I have represented and do represent a number of corporations in the $20 to $40 million business range. I think that experience is useful to me as a municipal attorney because you get a good sense of what people are looking for when they're dealing with government. Because of the representing municipalities, I've done a lot of work for person seeking zoning permits, development authority. I'm currently serving as a court-appointed trustee in Walpole for a 90-acre parcel of land, and was engaged by the court for that position principally because of my experience in governmental law, and we're in the process of trying to sell that. I would submit to you that all of the firms that you're interviewing tonight can technically do the job. There's none of us that don't know the law. We all have great experience in it. What I'd suggest sets us apart, if I can say so, is me. And it's how one approaches a position. We're not a large law firm, and we are completely accessible. I think those of you who have dealt with me know that. It's accessibility. Can you reach us? Do we respond to you? You will be, as you always were, a very important client to our law firm. We're highly responsive. You'll have our home phones, you'll have our cell phones, you'll have our emails. We're all burdened with the BlackBerries, and so we respond. It's no good to have a smart lawyer unless you can actually call them and get some answers. And the way I would see the firm representing you is that I would be town council. Everything that was happening, I'd participate in, know about, and supervise. I personally don't do the research myself. I supervise it. I know everything that's in Sharon, for example, that's going on. I've known everything when I was town council here. that's going on, but you will work with our law firm as well. The other thing that that I bring to the table is an historic knowledge of this community. I mean, I don't think anybody knows more about what's been going on in Foxborough over the last 35 years than I do. I know the players, I know the people, I know the interests. And I think I've developed a relatively good reputation during that time. So it's accessibility, it's experience, it's responsiveness, the cost and the cost control measures. We're well aware of what's going on in municipal finance. The billing rate that I proposed is embarrassingly low, frankly, and it's much lower than I charge private clients, but it's what governments can afford. You do have and a good one, you have a system in place where the use of town council is controlled through the town manager. That's a good idea. When we see something coming across our desk that we know will be expensive for you, we talk about it, we let you know beforehand, so that you don't get surprised at the end. Litigation is sometimes necessary. I think those people who know me know that. Not that I dislike it, it's just most of the time simply not in your interest to litigate. It's very time-consuming. It's very expensive. It's sadly unpredictable, given the nature of our courts. So we like to not do that. Sometimes you have to. And in the years that I was town council, sometimes I did, with, I think, some success. But, you know, that's something it's good to try to avoid. I don't like when boards within a community have disputes with one another. That's something we should all try very hard to keep from happening and to control it. It isn't that difficult to do when everybody has goodwill and openness for one another, and so that's something I try to avoid. The way we bill in increments of tenths of an hour. We describe, as you've asked for, what's done in the bill. Sometimes people don't like the bills, so we're always happy to resolve that with long-term clients. But I mean, but really what I think is most important is counsel. You need to. A lawyer serves two functions. He's a technical advisor. You read the law, you know what the law is, and you tell the client. But good lawyers are also counsel. They're counsel. You're looking for their judgment. You're looking for their temperament. You're looking for their veracity, integrity. And, you know, I like to think that we bring a lot of that to the table. The relationship is the highest fiduciary relationship that people in the business community can have. We owe all our clients, all of them, great faith, utmost honesty, integrity, openness, and that's what we offer to you.
Thank you. Now we have, as I had said, 5 questions, and we'll go through these. You have 15 minutes, so a couple minutes a question. Linda, you want to start off with the first one?
Sure. Describe the most significant litigation involving your firm as town council for a municipality. What were the subjects of the litigation, the outcomes, and your firm's contribution to the outcomes?
Litigation, Linda?
Yeah.
Actually, the thing that first comes to mind is when, it was many years ago, when the stadium, when I first became town council, the then owners of the stadium, which were the Sullivans, wanted to sell beer throughout the entire game. I think, as you know, there's a cutoff now. I think it's 15 minutes after the start of the first half. We litigated that issue before the ABCC, and it was successfully litigated, and I had the board at the time, we wrote a board regulation, a Board of Selectmen regulation, cutting off the sale of beer at the time we did, and we were successful in winning that. I remember it was Eddie McCormick, who was the former Attorney General, was on the other side, and walking into the courtroom, and everybody was saying, "Hi, Eddie, how you doing?" It seemed like in the way. So we litigated that. We have in the past, Linda, also litigated licensing issues for the town. We've had Superior Court litigation, also successful on that. Everybody remembers the Michael Jackson litigation, and we won. I don't know if I'd call that a success, but that was pretty significant at the time.
Okay. Thank you. Ginny, second question?
Regarding commercial development, describe the breadth of your firm's role in a major commercial development on behalf of a municipality. Give specific examples describing the complexity of the projects, local impacts, and then describe the outcome.
Well, I had the great good fortune to work for many years with Selectman Michael Capola. And my involvement in the stadium project, I'm talking about the existing stadium project, was, I was at the table for 3-4 years. And that included presentations to the legislature over a year and a half, dealing with the selectmen, dealing with the water and sewer commissioners, responsible for the purple pipe system, the recycle system, negotiating the lease, representing the housing, the Development Authority in Foxborough for a $70 million bond issue. And with some luck, we got the stadium. That was obviously a major commercial development. In Sharon, I represented the town on a 600-unit, 360-acre, $50 or $60 million development project. I did the development agreement, did the zoning, did the work between the town and the developer. I'm currently representing Sharon on Sharon Commons project, which is a major development right on the other side of Route 95. Limited, Jimmy, to municipal work? Is that something like
Yes.
that? Yeah. This is, in a sense, municipal. My work as trustee in Walpole is to develop that property. And so dealing with the town of Walpole, the town administrator, and the boards over there, running through one subdivision on one side of the property and what was going to be an agricultural development on the other, but that's a very large, multi-million-dollar development. I've represented the city of Quincy on the naval base. When that was redeveloped, I represented the city on a contract matter, big development, and won that case. That was a litigation case, actually, Linda. We won that case on summary judgment, which is an accomplishment. And but those are the major development projects I've been involved in.
Thank you.
For governments, I've done a lot in the private sector too. But
Thank you.
how are you, Lorraine? Good to
How are
see
you
you.
doing, Dave?
Great, thank you.
When the Board of Selectmen asks you for a legal response, please explain when you think the requested advice should be in writing. When do you think a verbal response should suffice? Please state your opinion as to the difference between the two.
Yeah. Whenever we can, we like to give written opinions because they're better, they're more understandable. Everybody can read them, can follow them, and they're open. There are times, frankly, though, when a board will want to know an answer and not necessarily have that opinion published. And so when I know the answer is not going to be what the client is wishing for, what you're wishing for, I'll discuss that with, I usually deal with the chairman of the committees, and if you don't need to be burdened with that in writing, that's fine. I don't know if you all remember Troy Earhart, the superintendent of schools from years ago. He's a great guy. And Troy always had the good sense to call me up and say, "What do you think about this?" And I tell him, and he said, "Don't bother giving me a written opinion." So it's a judgment call, Lorraine, but almost without exception, we do provide our opinions in writing to the board. Yeah.
Thank you.
Thank you. Do you give binding single-fee quotes for work on specific projects? If so, please give some examples.
Yeah. Generally not in the governmental context. Our billing for almost everything is on an hourly basis. I've found over the years that that's just fairer to the client and fairer to my firm. I'm open to it, but the problem with it is it's so hard to predict where any matter is going to take you that somebody will be disserved. There'll be disservice to either the client won't get disservice, but we could, and you could wind up being overcharged, although I doubt that would happen. So I generally don't do that. I get what's going on in government and finances these days. It's a very difficult time. And so, we're aware of that, but I don't think the answer is a flat fee. So I wouldn't recommend that. And even my private clients, I almost never do flat fee work. It's just too unpredictable. Even in the areas of law that you know really well, I do a lot of franchise law, and so I review franchise agreements fairly often, and people like to know, well, what's it going to cost? And you just don't know. I mean, you know how to read the agreement. You pretty much know what it's going to say, but you don't know how the other side's going to react to you. You don't know how law firms that you're dealing with will respond to you. So,
okay, fair enough. Thank you.
Okay.
And Mark has the final question.
Mr. Sullivan,
I get the best one.
you get that. I'm out of answers. I don't bother.
I'm sorry, James.
Yeah.
Please tell us about a mistake you made advising a town, how you notified the town of the mistake, and how you corrected it.
See?
Well, I don't recall having the kind of mistake in legal opinion, you mean?
Yeah.
Advising, yeah.
And everybody, just got the same questions. We just
everybody had the same response that you had.
Yeah,
right?
I appreciate
it.
No, I mean, I don't think that's occurred. I'm sure sometimes the law is not clear, and you come down on one side or the other. And I don't think I recall a case where I give an opinion and then it was clearly wrong. But if my advice or my opinion on something is not correct and I find out about it, and I'm sure it's happened, I just haven't recalled it. I guess you bury those things. You let the client know right away I was wrong, and you tell them right up front, and you bear the burden of the cost of correcting it. And, you just let the client know. But I'm certainly not perfect, but those things never happen, Mark.
Yep. Okay, thank you. Those were the questions. So if you want to entertain 5 minutes of a closing and thoughts.
Well, thank you very much. It's really a great pleasure for me to be back here. I guess I'll just repeat some of the things I said. Whoever you hire is going to give you the right technical advice. We all know one another, all the firms, and we all read the same books in the same cases. With us, because of our size, you'll always be able to reach us. You have my cell phone. We're accessible. We're responsive. We're located 15 minutes from here. Last time I applied for this job, I was 2 minutes from here, but I'm a little farther away. All of the lawyers live in the area. Mike is even committed to marry somebody, a Foxborough woman, so that's commitment by her.
Yeah.
Right? I, however, will not
That's
do
huge
that.
points, just so you know, huge points.
I'm not doing that. So it's that. We know about, we understand costs, we understand municipal law a lot. And by that I mean you have to understand the politics of it And by that I mean you have to know who you're dealing with. You have to understand the ramifications of your advice. You have to know how to talk to government officials. I have tremendous respect, and this is, take the job or not, but I have great respect for all of you and for your willingness to serve in what has obviously been to many of you a very, very difficult time. Very difficult, and I appreciate that, and I have great respect for people who do that. John Adams was a selectman, so you're in great company. It sounds corny, but I'm very honored to be here. I hope we get the job. If we don't, I really wish the town the best, and however you go forward.
Great. Thank you, Dick.
Okay.
Thank you, Mike.
Yes.
Thank you very much for your time.
Yeah, you look great. Great.
My son took me on a 15-mile hike Sunday.
Oh, wow.
In the White Mountains. So.
Oh, wow. Still recovering.
Thank you. It's nice to meet you.
Nice to meet you. Okay.
Thank you.
Nice to meet you, Mike. Thanks.
Guys all set to keep going?
So, keep going with what?
We're done with that.
Yeah.
We did the 6 interviews.
Yep.
My thought process coming in, and that's why I put this kind of matrix at the end, where we would rate all of the 6 firms 1 through 6. And if we get consensus, we look at these and everyone comes up with the same firm as number 1, it kind of gives us the answer. If it's close, maybe we want to interview the first 2 or maybe the first 3. Those are my thoughts, and I haven't shared them other than information in the packets for you guys. But I'll entertain what you guys want to do.
Or
well, I was thinking where we've had the packets for a while. Now we've had the interview; it's fresh in our mind.
Yeah.
At least we can rate them, and then see where it falls. We don't have to make a decision tonight. Maybe if we discuss it, you guys feel comfortable about making a decision. As you know, the agreement that we have now with the current council, it's going month to month, so there's no dire straits to get this done tonight or next week.
Right.
It's been lingering for a while, so I think where it's fresh, everyone's done a tremendous effort to put stuff in. I think we owe it to tackle it and get it done as soon as we can. But it's already been 3 hours. If you guys are tired and want a fresher look, go back and revisit it, and then come back.
There's just some things that I want to take these notes that I made this evening and go back to my packets with.
Okay.
Kind of compare.
It's just
the process with the
something that I didn't. Yeah, there was a couple things that I didn't think of to kind of get
There's
into.
some real close candidates here, and I think some of the bidding would separate the two. To give it a categorization 1 through 6 here, which I've kind of already done. I'd like to do the same thing Linda's talking about. Compare the rate, flat rate, the this and that, and all
Just
that.
a couple things I didn't think of.
Yeah, that's fine.
And get back and and have it on the agenda in the future.
Yeah, I mean we can certainly fill these out. I think over the next week and get next Tuesday hand them back to you for you to.
So would you want that on as a? I'm just trying to think of the logistics. You certainly, if we're not sharing the information, you can email it back to me before Tuesday, and I can get it on the agenda as an item.
Are we really booked next Tuesday?
Next Tuesday, we have the goals and objectives for Kevin Pecos, the town manager. I just added. Linda and I went to a meeting last night with the water and sewer. I haven't shared this with you guys yet, but I just put it on the docket for next Tuesday to discuss. The Patriots went to the water and sewer, and they want to come in front of the selectmen to give their thoughts and ideas of moving forward with the billboards, trying to sort out that whole mess, and kind of give us insight onto what they're thinking. And hopefully we're past phase 1 of a mess, and we can take the time to work together to move forward. So I thought that was important enough to put on next week's agenda for a half an hour.
Yeah.
So those are 2 of the big ticket things. We still got to deal with the not the fire contract, the overtime, which I don't want that to get lost, so I wanted to put
Yeah.
kind of turn the screws a little bit to get the
Right.
fire chief, Kevin Pecos and Randy, to do those items of reevaluation so we can make a decision, because we still got to do the police overtime, and this is dragging into the summer. So I think those three are the big issues that are on the agenda. And then there's probably 3 or 4 little ones.
Well, James, we have the meeting with the planning,
That's next Tuesday, we have our regular selectmen's meeting.
And then
Thursday,
Thursday-
we have the joint meeting
Joint
with the
meeting,
planning board.
yeah.
what, could we put it on with that meeting, for that, maybe, just a half-hour conversation, or?
That meeting is here, and it's the planning board meeting we're attending.
So
Okay.
they.
Oh,
So we'd have to go to a
Yeah,
different,
we'd have to,
yeah.
Right, we couldn't, they're not going to end on that one subject, so we couldn't just take the room after that, okay.
Well, why don't we do this? Why don't we put it on for a 20-minute discussion at the next agenda? In the
Just to say
meantime,
if we're close, because we might all be close, just like
Yeah.
you said, and
Yeah.
it might be a done deal
Yep.
of like, okay, we're going to bring so-and-so and so back.
so why don't you, if you would, everyone email me their 1 through 6, and this is a little, if it's not clear, each person gets a number, 1 through 6, so there's not number 1 and then 2 number 2s. It sounds silly, but it's you could do it either way. Email it to me, I'll put the matrix together, I'll email it back before Tuesday, and obviously, please don't talk amongst ourselves with it. Does that make sense?
Yes.
I just, one other thing, the last time that we did this, I know at the very end, whatever was presented for financial proposals, I remember Andy had negotiated the final cost, so like whatever's there was...
Oh, yeah, that's a good point.
you know.
What you have in the packages are what they're proposing.
Right, it's not the final.
Yeah.
It isn't the final, no.
And you
No.
sit down with,
Right.
you work in the deal, and you may not like that, and that's
It-
the time to
it
do it.
goes-
So
right.
if we're all unanimous on firm number X,
Yeah.
we're not bound by this proposal. It
Exactly.
brings us into the negotiation tables.
Yeah.
And then you can go through that process, and it may be a failure, and then you go to the next choice. So we're not
Yeah.
making a...
No.
But we've got to whittle, we've got six. Some people may think that was too many. I thought there was a benefit for
I think
hearing
it was
the
great
big firms,
'cause-
the small firms.
Because we only had the 6, I think it was good.
It's everybody that applied.
Yep.
So, it's all good.
When you
Go ahead, Tom, Chief.
when you want our ratings, do you want justification for them? Do we have to justify? what we-
It's
No, I
almost
think
like
the
a straw vote, almost.
Yeah,
like,
I think
you
the
know?
justification, when we're all together, I think that's the time to
All right.
bring it out in the open. And maybe, if it's tight, your justification may sway somebody else, and they may change, so we can get some consensus.
Yeah.
But I think that has to be done in the open, and I don't think I
That's
want
why
that
you kept-
information.
Keep your notes, bring them to you, and bring them with you when we have the meeting,
Okay.
Everybody's taking good notes, I could see.
Yep.
All right,
I just
motion
want
to
to,
adjourn?
I just want to
Go.
ask if I could make sure I get everybody's goals back, and I can compile that.
Last time, there were 2 people that didn't do it.
Yep.
Did you do it?
There's 2 males.
There's still 2
It was
people.
Still
actually
2 people.
Who didn't
It
do
was
it.
2 males that didn't.
I'm just glad I'm not the only one. I was going to throw Mark under
I
the
think the
bus.
girls did.
Again.
So,
Girls know what they're doing.
Yeah, you
We ain't
guys.
going over my head. Motion
So-
to adjourn.
Second.
All those in favor?
Aye.
Aye.
Thank you, Pauline, thank you. It's a long night.